May I please your lordship? I bid for 30.
Why?
As on for the day.
Hmm?
As on for the day. I think it is not well. The vote.
The request of the Lord is up to the top of that.
What is 2 weeks?
4 weeks.
Fair play, Sir. Next to recommend item number 21, 22, 23, 24. This matter may kindly be passed over for a day. The
Why?
senior is out of station. If he will be reaching by 4, which is any date after 4 years.
Matter pertains to what?
The repetition matter pertains to contract work. Lordship,
For what?
there is a contempt case also, Your Honor. Lordship, contempt case also there.
It is
Despite
state.
no stay. So, despite passing the order, they haven't paid the bill amount.
Request of the Lord is up to the that said to solicit.
Right.
There's no stay.
No stay.
You have taken the info consent from the other side.
Contact them. Contact them.
Oh, no, I could. Sorry.
I'll inform them.
No.
May I please your lordship? I beg to mention item number 9, lordship. Lordship, we have filed an additional affidavit yesterday, which is not in the record. Which is not in the record. So, lordship may kindly attach.
We'll see if the matter takes.
May I please your lordship? Lordship, I beg to mention item number 27, lordship. Lordship, kindly matter be open for 1 week, lordship.
Right.
Because lordship, matter is listing after 1 year, lordship.
So, very good. At least the matter is listed.
After 1 year, lordship.
So?
Lordship,
So that
today,
you have the file.
file is,
Very good. Don't worry. I'll help you up.
Made the good. This is an interlocutory application for impeaching response 7 and 8 as party response.
Matter
This is regarding content yes, man. The earlier incumbent has kept the office, so the new incumbent has joined matter. Response number 7 and 8. One is defense district officer, Guwahati, and response number 8 is the district commissioner, Kahu.
is the direction.
Direction manual page 16 of the content petition. To pay the zero compensation as well as the compensation for acquisition of land. Altogether, there is 6 direction manual.
So what are the what is the affidavit? The date for what is yes, that the payment has not been sanction has also been granted
Yes, correct.
at page 30. Why payment has not been
Hmm?
Who?
Why don't is the
Who is the pay? No, not the mistake. You have paid, you have taken the cash to release the photo. Yes, madam. Why the payment has not been made? Sanction has been duly granted. Why the payment has been So he's not appearing.
And
Was the earlier deputy commissioner, we call him. If the respondent is not represented, court has not excused that. We call this person. What is the name of that person? Addiction to page. Much time this people will keep on going on. I think. Yes. Love Jah. Love Jah and Bittu page. So they are not represented. We'll ask this for the appearance of them to the lawyer. We dispense with it and asking them to be present in person. The instant contempt application. But how much time these people are going to keep on fighting, and every time you keep on changing your people? Amount has been sanctioned.
Yes, madam.
Then why the payment has not been made?
I'm not sure why they are not releasing the amount. Madam.
Yes, Mr. Nath, why the payment has not been made? The amount has been duly sanctioned.
From deputy commissioner side, my impression is that the kindly see the directive.
Huh?
Kindly for a moment. So the direction
16.
page 16. The deputy commissioner Kamrup Metro shall release the unpaid compensation of 20 lakh 51,000. This has been paid. This has already been paid.
These 20 lakhs have been paid.
Yes.
Okay, then.
It was paid. My instruction says in the year 2015 it is.
Hmm?
It is
Deputy
already.
Commissioner shall release the direct compensation of rupees 14,000. That has been paid.
This was sanctioned and it is already
Paid.
yes, suspected.
After this, shall release the above payments to the petitioner if not released within a period of 2 months. So this has been complied.
Yes. this has
Now
been-
the government of India, they have already sanctioned an amount of some 55 crores.
my instruction is that the instruction so far I see that we have already communicated the requested for the amount that we have not received. But this instruction is sometime earlier to the up to date instruction.
I don't understand you. Kindly see the affidavit filed by response number 1 and 2. And that too on 7/7/2021. The amount of 55 lakh, 55 crores have already been sanctioned.
So if it
I'm
is
directed to convey the sanction of the president to the acquisition of land of so and so. As per under the so and so. And the amount is debitable. Have you received the amount or not?
that kindly keep it some type of
Does it take 2 years for that? Okay, I give you time. 2 o'clock.
I got the IA copy.
Where about I? How much recently the Supreme Court has come up with a very important judgment on this contempt matter. So therefore, don't worry about making all these people see that every time. You're taking it as to get your information as to amount to whether has been received. The order, this sanction was granted on 7/7/2021. We are in 2024. Does it take so much of time?
But I'll just get the update.
2 o'clock.
Yes.
These type of matters cannot remain.
Sir.
Sanction has been granted. And,
Whatever- whatever-
and the problem arises, do you know why? Once the sanction has been granted, on the basis of an estimate made by you, and the possession having been taken over, who is going to pay the interest thereafter? The deputy commissioner going to pay from his own pocket?
No,
If his department have already got the money,
no, whatever amount they have received, that is already.
that
been
is earlier.
I'll
But this 50 was not 7/7/2021. Have you got the affidavit of
That is-
response number
that is-
1 and 2?
that information I don't have. Just
Yes,
I'll check.
give him the affidavit. Now, Mr. Khatrunier, you have the affidavit of the response number 1 and 2?
I'll take it.
There, it has been categorically mentioned that on 7/7/2021, the sanction has been granted. So under such circumstances, the money must have immediate. If not then, now to 2024, the money has already come. Then why the petitioner have not been paid? The problem arises because there will be a question now of interest. Who is going to pay the interest now? And if the petitioner have not got it, then the action has to be taken against the people. And you look into the file. If they say that the payment has not made, then you are answerable. 2 o'clock. What about your senior? 2 o'clock. Huh? 2 o'clock. Let the council go or ask that person. For true for Yes, who is appearing for petitioner? Who is appearing for the respondent?
I'm appearing for the I'm appearing for the
Yes.
in this matter, matter one affidavit number 55, respondent number 1.
Who is there? Yes, what has happened in respect to the judgment indoor municipal corporate? Attack. You are for? Who are you? Yes. What happened? Did you deposit the amount? Yes. To him. What is the impact of indoor municipal corporate? Expert. The toll tax. Or tax. So, about just method of saying that what about what but root of tribal the purpose None has appeared on behalf of the petitioner on call. Ms. M. Burman appears on behalf of the respondent number 2, 3. The able appears for respondent number 1. And Mr. P. Garodia appears for respondent number 5 and 6. None has appeared on behalf of the respondent number 4, that is the Union of India, as well as the respondent number 7. The instant writ petition has been filed by the petitioner seeking a direction upon the respondents not to requisition the petitioner's land being contiguous and similarly situated to the land of the SOS village, semicolon, a direction to the respondent competent authority to issue notice to the petitioner under section 5A and any other relevant provisions of the Land Acquisition Act on the ground that no notice whatsoever was issued to the erstwhile owner of the seller and thereupon to take consequential steps, including payment of adequate compensation and or exempt the petitioner's land measuring 10 acres, 14.5 acres for the acquisition. Pursuant to the filing of the writ petition and notice being issued, an affidavit in opposition has been filed by the respondent number 1, stating inter alia that there was a notification issued under section 4.1 of the Land Acquisition Act 1894 for acquisition of 74 bighas, 1 katha, 4.5 letters of land at village Mirzapur. On the basis of the said notification, on the basis of the said acquisition, that the said acquisition proceeding were registered as LA case number 2/2008. Objections were also invited from the patadas of the persons interested under section 5A of the Act of 1894. However, the said notification lapsed. Subsequent thereto, another notification was issued on 22/11/2010 under section 4 of the Act of 1894. Pursuant thereto, notices were also issued to the Pattada and hearing was conducted in terms of section 5A of the Act of 1894. Subsequent thereto, report was submitted and the declaration was made under section 6 of the Act of 1894. The record further reveals that the award was duly made, was duly passed, And the requiring authority, that is the Airport Authority of India, had also deposited the awarded amount. Thereupon, an objection petition was filed by the petitioner, bearing number 653 dated 7/5/2012, that no compensation be made to any party concerned, and the entire amount is still intact at the disposal of the Deputy Commissioner. It is relevant to take note of from the pleading, from the orders passed by this court, that a question duly arose as to whether the petitioner would be entitled to compensation in terms with the provisions of the Act of 1894 or under the Right to Fair Compensation Act 2003. In view of Section 24 of the Act of Act of 2013. In view of Section 24 of the Act of 2013, the record further revealed that on account of the issue being pending before the Supreme Court in the case of Indore, in the case of being pending, the matter was adjourned on the last occasion. In the meantime, the Constitution Bench of the Supreme Court had already decided the applicability of Section 24 in its judgment reported in Indore Development Authority versus Manohar Lal and others, reported in 2020 HSCC 129. Paragraph 336 of the said judgment being relevant is quoted herein under. From the above quoted paragraph, it would be clear that the Supreme Court, that the Constitution Bench of the Supreme Court had observed. Is it the Constitution Bench? Sir? Okay. Had observed that the expression paid appearing in Section 24(2) of the Act of 2013 does not include a deposit of compensation in court. It was further mentioned that non-deposit of compensation bracketed the court does not result in the lapse of the land acquisition proceeding. It was observed that in case of non-deposit with respect to the majority of the holding for 5 years or more, compensation under the Act of 2013 has to be paid to the landowner as on the date of the notification for land acquisition under Section 4 of the Act of 1984. It was also observed that in case a person had been tendered the compensation as provided under Section 31(1) of the Act of 1894, it was not open to him to claim the acquisition had lapsed under Section 24(2) due to non-payment or non-deposit of the compensation in the court. Inasmuch as the obligation to pay is complete by tendering the amount under Section 31(1) of the Act of 1894. It was further observed that the landowner who had refused to accept the compensation or who sought reference for higher compensation cannot claim that the acquisition proceedings had lapsed under Section 24(2) of the Act of 2013. If these propositions are in the backdrop of the above, if these propositions as settled by the Supreme Constitution Bench of the Supreme Court is taken note of, and applying the same to the facts of the instant case, it will be seen that it is at the behest of the petitioner. The payment of compensation has not been made, although the petitioner was duly tendered the said amount, as could be seen from the affidavit filed by the respondent number 1. Under such circumstances, it is therefore the opinion of this court that the writ which has been sought for in the instant proceeding cannot be issued. Be that as it may, this court, however, observed that the petitioner has been diligent and bona fide on due advice have been pursuing his remedies before this court by filing the present petition. And it has been pending since (09) 2012. Under such circumstances, this court grants the liberty to the petitioner, if so advised, to file applications before the Deputy Commissioner, Kamrup, District Commissioner Kamrup, under Section 18 of the Act of 1894, read with Section 64, file application before the District Commissioner Kamrup Metro, seeking a reference as regards the if it so aggrieved with the inadequacy of the compensation. The said application has to be filed within a period of 42 days from the date of the instant order.
Deputy
The
Commissioner
above
Kamrup Metro. Deputy Commissioner Kamrup Metro, as per respondent. Kamrup Metro. As per respondent. Okay.
plan appears on behalf of the petitioner or court. The record repeats that on an earlier occasion also the petitioner was not present. Subsequently, yes, Mr. Gopal, can I take up this matter?
I was wondering, otherwise, my lord, similar cases series has been disposed.
No, the-
By now, probably all these petitioners have been issued notice as matter, whether they are still there. That's the matter, because there was an order passed, it is dated, my lord, 31/5/2018 by my lord Justice M. Bhuya at that moment.
That I think I appear. You want that that order
Then
to be.
it will otherwise solve.
So
Fine.
I don't, but I was the
One of the
it's the matter. But the petitioners have not been representing.
Yep.
They must have lost.
Yes.
Anyway, none appears on behalf of this matter. Yes, what is it?
it is asked for.
Yes, you filed an affidavit for that.
Yes, sir.
What happened?
Then that, kindly see the affidavit be.
What is your basis of asking on the basis of appointment?
The petitioner's father was killed by the extremists in the year 1993.
Then?
There was a scheme at the relevant point of time,
But that has already been taken over by the 2004.
2004.
Yeah.
The 2004. But there was a provision that was inserted that they would be paid an ex gratia amount of rupees 3 lakhs. Now, they have filed their affidavit. According to their affidavit, they will pay this amount of rupees 3 lakhs, and the amount will be disbursed by the finance department. That is their case. So, what I
Because
like,
you see, if I remember, I had dealt up with this type of matters. Earlier, yes, there was a question of appointment, and then there were various the correspondences and all, and which resulted in they coming up that instead of all this appointment business and all, we are going to pay an amount of that happened in
2004.
2004.
2004. And
We
there
are
are
going to pay an amount of rupees 3 lakh, 2 lakh, 3 lakh.
3 lakhs, 3 lakhs.
Then there are many repetitions where earlier persons have died.
Yes,
The earlier persons
Died who before 2004?
but they were initially getting 1 lakh. Then there are many repetitions filed where they are asking for this 2 lakh. And this court is passing directions in view of the division bench judgment.
Yes.
Reported.
Thereafter, there is a judgment of this court. The person who died before 2004, they will be guided by the earlier rule. So meaning thereby they will get ex gratia as well as the appointment letter. Be that as it may, this Honorable Court has passed an order for payment of executive amount. This amount may kindly be disbursed at this stage,
In terms of the
They filed an affidavit, we are going to pay.
What the finance department will pay, we have not made the finance department as a party.
No, they will
Uh,
pay their, in fact, finance department pays or whoever pays, we are not concerned. Finance department only gives the note. They only grant the sanction, nothing more than. And when the additional advocate general is appearing for the state, which includes every department. Yes.
not permitted. Those things not permitted.
Raise the petition because
So that was mentioned in our review.
the instant petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authority in not taking steps for granting an appointment for giving an appointment to the petitioner in terms with the provisions of the Assam Public Service Record appointment of family members of persons killed by extremists of the terrorist record rules 1992, as well as the ex gratia amount payable to the family members of the deceased.
This is petitioner.
And with
Sorry,
yeah, petitioner with
sorry, sir.
of the on the materials on record, it repeats that the father of the petition, late Bhupendra Narayan Bosumotari, was a grade 4 employee of the irrigation department of the government of Assam. On 15/6/1993, he was killed by the extremists at his residence by shot by residents. In the case of a petitioner that at that relevant point of time there was a notification, there was a the government of Assam in the personal department had issued a notification in respect to a set of rules known as the Assam Public Service Record appointment of family members of persons killed by extremist public terrorists record close rules 1992, or short the rules of 1992. In terms of the said rule, and more particularly Rule 4, one affected candidate from one family would be eligible for being given appointment to a government job or job under the state government undertaking of the court. On the basis of the said rules, the petitioner therefore claims that he should be granted a job by the concerned respondent authority. In the meantime, it is however relevant to take note of that on 22/6/2004, The said rules of 1992 were repealed. And on the basis, and upon repealing of the said rules of 1992, it was decided by the government of Assam that the ex gratia which was to be paid earlier would be enhanced to an amount of 3 lakhs. Therefore, the record revealed that there were various litigations as to whether this ex gratia, which was announced by the government of Assam by the communication dated 22/6/2004, would be granted to those persons who were killed by extremists prior to the said notification. The said issue came up before the division bench of the court.
I've got. I did a-
In the case of Sri Dhaneshwar Basumatari versus State of Assam, in WPC number 3355/2007, it was opined by the division bench of the court that the said benefit of a ex gratia payment would also be available to those persons who were killed by extremists prior to the issuance of the said notification. The said judgment in the case of Dhaneshwar Basumatari is reported in 2010 TJLT. আগতে লিখি না Dhaneshwar Basumatari reported in 2008. The observation of division bench and observations made by the division bench, more particularly at paragraph number 9 and 10, nine, 10, 11, and 12, 11, 12, and 13, being relevant, is reproduced here in under. On the basis of the said judgment passed by the division bench in the case of Dhaneshwar Basumatari Supra, an office memorandum was issued on 29/7/2013 by the Personnel B Department of the Government of Assam, whereby it was clearly stated that in case of persons killed in extremist violence prior to 2004, but whose relatives did not apply for any appointment prior to 22/6/2004 and had applied after 22/6/2004, or may not have received ex gratia grant under 2004 notification, that is rupees 3 lakh. A, they shall now be given appropriate ex gratia payment as per the notification bearing number APP 121/92/PT Roman 5/136 dated 23/6/2004, adjusting the amount already received, if any, and B, they shall also be entitled to be considered under the scheme envisaged in the government circular bearing number ABP 121/92/PT Roman 5/136 dated 22/6/2004. And when did you apply?
It possibly silent on that.
Hmm?
It is silent. Yes.
No, before, before 2004.
Para 4 to carry it here.
And then why did you file the writ petition in 2017?
Prior to that, we have filed 2 writ petitions. It's the third round it is.
Then when did you apply?
Never applied. Ultimate time the affidavit we have given the cases developed. 2015 case was still rejected.
The paragraph formed in 2003. At the time of petitioner, at the time of the petitioner's father's death, the petitioner was a minor of 12 years. Thereafter, therefore, he could not apply for the employment. He passed higher secondary examination in the year 2003. After passing higher secondary examination in the year 2003, he applied for his appointment in the government job.
You are saying that you were 12 years in 1993 and you passed your higher secondary in 2003
Yes.
in 22 years. When did you apply? Without that date being mentioned, how can this court all take note of? This is totally a vague statement.
But prior to that, there was an
Five eight zero. Then you did not file contempt.
no, well, not filed in court.
Para of the petition referred to filed by the petitioner earlier. That order will be the next.
Yes. The arrangement for appointment on compassionate ground is being arranged by only the fund for providing ex gratia grant of 3 lakh have not been. What happened? This is of 2000. It is the part of the requisition. And you don't have. See this newly interested. And the second thing is, why the government has not paid? There was a direction in 2015.
Order. Page 47, 45.
No, kindly see page 30.
Page 47 is given the present status
No, we are not concerned with that. Page 30
of the
of the petition. Why haven't you paid this till date? This is an order of 2015. We are in 2024. This is a clear case of non-compliance of the order passed by the court. And are you saying that after so many years now you are going to pay? What is the big thing you are doing?
document kindly can't be.
No, page 29 and 30. Answer that first. When there is a direction by the court to pay in the year 2015, why the payment has not been made?
That has been dealt with in
But page
page 47. F.
that was, but it is
The meeting that was held and petition was taken for which it was directed to file affidavit. As per instructions of the Chief Secretary, Assam, a meeting was held in person for of Chief Secretary on 26/7/2020, attended by the Revenue Officer Management Department, Department and District Department of Assam, regarding compliance of the airport order 29 in respect of the and subsequent orders of 40 of the 351/17. Following points are discussed, repeat, as per order 5 in respect of the 4530, had directed the point of the department.
no. I have to look in. But the question is, payment of is to be made by whom?
This was the issue. The two relevant parts were not the party.
Payment, you see, here we have the personal department. Who had issued this notification? The notifications have been issued by the personal department.
This is what you have to clear.
Does the notification of 22/6 say
Yes.
that the payment would be made only by these authorities, by that department?
Page 56 note 29/7 6.
20, page 21, official correct. These are all issued by the personal department.
And by page 47, that was rejected. 49. The document kindly have to look at page 49. communication 31/10/2015. There is the order it is where the pass by the secretary. Also, there is a notification dated 29/7/1995 wherein it has been decided to provide executive for luck each to NFA for it is stated that it is from 1/1/15. Also, there is the document of 29/7 which was provided to remember state government employees, home guard personnel, army and central paramilitary forces are engaged in
Mr. Dasgupta, you kindly give, I'll fix this matter again, it's Monday. Give the bank details of that person.
Bank?
Details on Monday. Monday, get the bank. And on that day, we want the money to be paid by next Friday. What? 2015, this is it. The direction is asked. This the matter again on with the matter in 5/2/2024 at 2 p.m. Mr. A. Dasgupta, the learned senior counsel, shall obtain instructions as to what as regards the bank details of the pitch. Mr. Muzumdar, this is not at all inspiring. But the conduct is absolutely in violation of the
Direct-
court order.
direct-
Yes, you can't appoint, it's a different thing, but does it take a decade on your part to release this 3 lakh rupees? And on one hand, now you are saying that we are going to give it. But the question is, you pay and the persons who were you
entitlement
and
with ballot
on the next day, Mr. D. Mozumdar, learned additional advocate general shall also apprise as who were the officials responsible for non-payment of the non-releasing of the ex gratia of 3 lakh as ordered by this court in it as per the order passed by this court dated demand in restitution of you give it that because then I will direct them to pay interest on this 3 lakh and that interest has to be taken from their salary. Not done.
document just for a concrete
No,
document.
Mr.
No,
I am not going to listen to anything. Absolutely, it's a violation of the court.
May I please, Sir?
Hmm.
My lord, this matter relates to acquisition of land, my lord. Kindly see the order dated 22/1/2024, my lord.
Yeah. Instead of order, but the court. Yes. Now you have got your instruction. As regards the finalization of the process pertaining to the sanctioning and dispersing the remaining of the state. What is your
I had, the Home Department has again paid the Inspector General of
For what?
For, for
For what purpose? Land.
well,
Your
for-
land
for-
was taken away
Yes, sir.
Yes, my lord.
For
and you have not
releasing
paid.
one, the part was paid. An amount of 5 lakh.
5 lakh has been.
No, it's okay.
The remaining part, matter.
Huh.
for
You
the
do one thing. Your land,
Yes, my lord.
how much area?
2 bigger,
Where?
1 katha, 13 lakh, my lord.
Where?
Under page number,
Where?
13, my lord.
Where? Where is the land?
Hahim.
I.
Oh. Construction of a outpost.
Okay. You do one thing. You pay him the 5 lakh. You return the land. You can't keep the land like this. Does it take so many years for you to settle it? You're ready to pay the 5 lakh?
Yes.
Yes. Return the land along with the house. You have construct. understand. Wait, there is no LAK.
Yes.
Have you initiated any acquisition proceeding?
this is only left at Jidat.
Had requested for payment of the remaining amount of land compensation in respect to the fund relating to so and so in connection with the acquisition of land for Haim. The same has been processed in this department and accordingly you are requested to examine the matter. What is this? Can't happen like this. Mr. Taluka, has there been any award passed?
This award is was my lord 11 lakh up.
Huh?
11 lakhs and all. From that award,
Possession has been taken.
but for it,
The instant petition has been filed. By the petitioner, being aggrieved by the actions of the respondent authority. In acquiring, in forcibly taking over his land measuring 2 bighas, 1 katha, 13 lechas, covered by dark number 288 of KP Patta number 195 of village Hahim under Moza Luki of Boko Revenue Circle under Boko Police Station in the district of Kamrup Rural. From the instructions placed, it reveals that some acquisition process have been initiated in being LA case number 12/2019 in connection with the acquisition of the said land for construction of the Hahim police outpost. The Taluka, can we say that the award has been passed?
apparently because that amount is to fix the 7 lakhs.
Has the award been passed?
It not. It has to
It
be
is-
otherwise-
It is not clear. From the submissions of the learned counsel, Mr. B.J. Taluka, appearing on behalf of the district administration, as well as the Home Department of the Government of Assam, as to whether any award has been passed in the matter. It's the matter again on 6th of February 2024, 7th of February 2024 at 2 p.m. Mr. B.J. Taluka, the learned counsel, shall apprise this court as to whether any award has been passed in respect to the acquisition of the land of the petition. And if so passed, when it was passed. The learned counsel shall also apprise this court as to whether the possession has been taken away and when the possession was taken.
Most of it.
And Mr. Taluka, kindly get your instructions. I'm not going to say next time. No. Because on the last occasion, you had taken time on the ground that you did not communicate. If you don't
I
communicate,
have-
then ask the police official to be present at the order, ask the secretary home to be present and by video conference. Yeah.
Yes.
Yeah, Mr. Ganguly.
Yes, on the last occasion, Lokit, I was asked to produce a letter of the deputy commissioner.
Hmm.
And
What
the
is your case about?
instruction is that the letter is not within the domain of the deputy commissioner. It is not.
What is your case? Not
Yes.
to issue
On 25/8/17,
declaring the
Lordship,
eviction of so and so.
the dargah was demolished, Lordship. It was raised to the ground, Lordship. And now we have come against that.
Going to be passed. We took against the 75 Act. And affidavit filed
affidavit file, Deputy Commissioner says that there is a condition that the premium is to be paid, and if the premium is not paid, then it will revert back to the district administration.
Rightly said.
Now, Lordship, they say that no premium is paid.
You paid the premium.
That Lordship, I have.
So you have not paid. Whose burden it is to prove before this court?
That
It is his
instruction.
burden.
That instruction. I
Then
do
That
not
was in 1990s. After the-
okay, dismissed. Unhelped.
That instruction I don't have.
You were asked to get your instructions on
No instruction. I was asked to produce a letter.
last time on the year on 15/12/2023. The event of failure to substantiate the validity of the appointment,
That letter,
the plot
Lordship,
of land in favor of it appears that it decided with the just court.
there is a remark in the Jamapandi Chitha that the circle officer has acted as per that letter of 1990.
use the supporting materials as regards the existence of the letter dated 12.
Yes.
Have you called up your
Yes,
client?
all the phone numbers are not traceable, Lordship. That is the difficulty. I called up. Lordship will give me some time, Lordship. I will try to get some.
The original is out.
See that
It said that so 1990 কয়েকশো চিঠি মর্মে আউলিয়া দরগাহর নামত আবর্তন ক্রমে সংৰক্ষণ কৰি ৰখা হয় উক্ত জমি 3 বছৰৰ ভিতৰত ব্যৱহাৰ নহলে পুনৰ record back to the document. It is not here. But they saying premium.
So this letter is not there.
Right.
This letter of 1990 on the basis of which the petitioner claims right over the land is not there.
Sita reflects the existence of that data. But
Why does then the district commissioner say further on perusal of the office record, it is found that there are no records relating to the letter number KRC 119 of the 1990 of the 5/4 dated 23/3. Who has made this thing?
the affidavit, was filed by the district.
So you did not pay the premium.
That instruction I do not have it.
This court by an order dated 15/12/2023 had directed the petitioner to obtain instruction and to produce the supporting material on the basis of which it claims the grant of settlement. Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, submits that he has not been able to contact the petitioner. Under such circumstances, this court, for the interest of justice, grants an additional option. Is a stay?
No.
No stay, na? Has it been demolished or not?
Yes, demolition.
Demolished. and accordingly lists the matter on 11th of March. It is made clear that if the petitioner is not able to substantiate its claim on the basis of the documents sought for by the order dated 15/12/2020, the court would be constrained to pass appropriate orders. Yes,
Accuse your lordship. My senior is on legs in court number 2.
the senior always takes time. Last time also, at the request of learned counsel for the petitioner, lift the matter after winter vacation.
Your-
At the request of the learned counsel appearing on behalf of matters and John, we did it after the Puja vacation. Now let us have it after the Bihu vacation.
No, your lordship. I
Yeah.
can seek apology for that, your lordship.
What
But my
apology?
senior will do the case today, your
If
lordship.
your senior is so busy out there, what can I help you?
He is not busy, your lordship. He'll
Then-
do the case. He's on legs in court too, your lordship.
So let him be there. Or you do ask him, and let me dismiss it, go there to court number 2, it's an appellate court. Go there. Let him stay there.
Your lordship, kindly
Can't help
thank
it.
him, your lordship.
Oh, very good.
It's a humble request, your
Let me do something for the people, for the revenue. How much court fee you have paid? Yes, Mr. Gogoi, what is the matter about?
They are seeking allotment, settlement, and also my lord, quashing of eviction notices both passed by the revenue and the forest department.
Why?
They say, my lord, they are occupying wastelands and they are landless people. And they are harping on a similar order of this honorable court at page 187. Way back in 1998.
It was long time ago. That time. And
And my lord, though they project that they were the people, persons who had approached this court, it's not clear as to what they are already there or not. They had filed one representation before the doesn't appear any date also. At page 192, pursuant to High Court order,
so these people want the land.
they want the prayer portion, my lord, see, they are
You want only one plot of land,
Your
314
one
bighas.
katha, 15 less.
314 bighas. 314 bighas.
How much land? Lot,
no, your lordship.
as per your land policy, यहाँ पर? It is in village. It is in village.
Ashadubi revenue with it. Ashadubi revenue with it.
It is in village or town.
It's in village.
Village.
It's a chore
Then
area.
5 figures. So 5 figures you want for all the persons, huh?
Your lordship, basically, the
Only
we are
5
extremely
figures.
poor and landless people, your lord. We're extremely poor and landless people. And
What?
our land has been eroded by water, your lord.
So what?
There is the case, your lord.
536 persons, 5 figures. How
No.
will they divide?
No, your lordship, the totaling land is 1,106.
No, forget about that. One person. One foot. Therefore, 5 figures. 5 figures for 500. Either you pay the court fee for this 500 or this court is at best. First of all, this court may not. You have to take the risk of paying 25,000 as the court. 536 in 30,000.
Lordship, I
Or you want to get your restitution dismissed very well. Or you take 5 figures. You are willing to give 5 figures to all these 536 if they really think.
Otherwise, my lord, let's see the annexes 117, page 170. One person is
Sir,
occupied
Mr.
500.
Gogoi, not necessary. I know this type of matters doesn't have. So better don't pay. Let me dismiss.
Your lordship, kindly give me some time, your lordship. I'll just
For
take
what?
some instructions from my senior at top.
Who is your senior?
MU Mahmood, your lordship. Moizuddin Mahmood.
MU Mahmood. Can't help it. What right you
Lordship
have?
kindly be taken as the last item of today. I'll kindly take the instruction as master.
4:45. You state last.
I have to take instruction. So it's okay.
Take instruction. As well as the
Okay.
material one. You want to have the payment.
Master.
Yes, what is this?
This case, one additional it will be raised in file country. Yes, sir. That has been communicated. The case relates to regarding limitation in respect of municipal holding. And I myself and my wife transferred a plot of land whereon a house is situated. The land measuring 1 kotha 1 that was it was transferred. But the house is situated on 3 ducks. Some portion of the house remain with us, but the entire mutation, the holding number 170 and 171 that those have been allocated to them. This is the case, Maladev. I submitted my application.
Now it has been done in the favor of the response number 6.
Just for number 3.
Why?
But entire holding that could not have been given to her.
How
Because,
much? Is that?
because some portion of the house remained with her.
You sold it.
Yes, sir. The house situated on 1 kotha 1 lesser to the reference. So I submitted a representation, Maladev, asking the assessment, copy of the assessment. That is next 7, page 26, but it was not provided. It was filed on 9/4/2004. And thereafter to Maladev, I submitted application on NX 24/5/2016, asking the assessment certificate copy of the assessment, but it was not done. So, Maladev,
Then kindly come to page 31. This is your letter.
yes,
What do you say?
yes, regarding cancellation of the booking.
Oh, isn't it a civil dispute?
Maladev,
Do you have any problem
regarding
out there? You have also initiated
giving of
this
holding
notice
number,
on the section
the
80.
existing holding, that a municipal court would have given notice to us and would have done Maladev, in presence of us. Without knowing anything, Maladev, entire holding the those have been transferred.
So as per that, why don't you file an appeal?
It was not right.
Huh?
Appeal was not right.
Then how can this court decide? First of all, just on the basis of this, you kindly see page
Only
31.
just
What is your stand? You see that Radha Sharma never purchased holding number 170 and 171. So do you have any document what Radha Sharma had purchased?
Maladev, Radha Sharma purchased, Maladev. These 3 documents I have submitted to an additional affidavit.
Yes.
I have
There's
filed,
no
but
additional
it has not come in the report.
So?
Yesterday I filed.
You have a copy of it?
Yes.
Good.
Holding number 170, along with the land that it was transferred.
So holding number 170 was transferred.
Yes.
Then?
But
Both of you were transferred.
yes, as per what in the CLD, both the CLD also it was mentioned. First it was sold to two persons, Sonaram Datto and Jogen Datto. Then Jogen Datto transferred by the CLD number 2233 2233 of 2007.
Then?
Well, it is holding number 170 man. So both the holding that is given to her.
Let us see your assessment done.
No assessment, the copy of
How did you get 170? Some assessment must have been done.
I asked for the assessment, copy of the assessment, but it has not been provided by the municipal court.
Your assessment also has not been given.
Yes, sir.
But you sold 170.
Tax receipt is there.
Then?
I have the
On the other hand, your representation to the executive officer is it has not been known the applicant that the holding number 170 were transferred to so and on the other hand, you transferred this to that the 170 you have already transferred.
yes, sir.
That-
Annexus 7.
Yes.
As per my information, they have transferred the holding along with the holding. 120
You are?
holding for her. I'm for the municipal court.
You transferred.
He transferred holding number page 47. 170 holding for her. Page 47. Yes, I do not deny.
No, he transferred 170.
170 it was existed. One by husband, one by wife.
But 170.
Both
But
of
what
them.
about 171?
171, both they have sold.
No, where is-
They have not annexed those 50. No, 171 that has been mentioned in two CLD. They have not annexed CLD. Both the only
Did you only execute two sales?
no.
How many sales did you execute?
Two CLDs we executed, and thereafter the land transferred to Sonaram. So he those two persons transferred to Radhason.
How much?
Same land matter. What we sold to Sonaram Datto and Jogen Datto, both of them subsequently transferred to Radhason, respond number 6. The holding number 170.
But both out land is 14.5 hectares.
14.5 letters and 6.5 letters.
Huh?
6.5 letters. By one cell is
No,
14
kindly
and
see. No, kindly see page 23. This was the sale of 14.5 hectares.
It
How
is-
much land did you have?
it is regarding the Komal join the petitioner.
Mr. Chaudhary,
No.
how much land did you have?
My wife's land is also included.
How much land did you have?
There is more than 1 letters land. The house is
No.
situated.
Where is the document that you have more than that? To me,
Statement is there, Malad, but
the Chaudhary, go to the. They have any problem, go to the. We have initiated by.
Only-
issuing a- The instant petition has been filed by the petitioner.
petitioner.
Being aggrieved by the action of the respondent Nalbari Municipal Board in transferring holding numbers 170 and 171 of ward number 6 of Nalbari Town in favor of the respondent number 6. From the materials on record, it transpires that the dispute involved in the present case is primarily a dispute relating to title over the land and as to whether the petitioners have transferred the land, their land to the predecessor in interest of the respondent number 6. So taking into account that the disputes involved primarily a civil dispute, and it is and the competent civil court can decide the same. This court is not inclined to entertain the instant writ petition. So consequently, the writ petition stands dismissed. However, liberty is given to the petitioner to approach the competent civil court as regards their rights over the land and the building standing over the land, as regards the rights and the right as regards the rights over the land and the building standing thereupon. The dismissal of the instant writ petitions cannot, however, be such proceed such period to in
So I am appearing for response 54.
keep it up.
Apply.
Attempt 10.
Nay, please, your lordship. What is the petitioner before your lordship? A old age lady, my lord, above 80 years.
What do you want?
My lord, she is claiming ex gratia of her deceased son, my
Hmm?
She is claiming ex gratia, my lord, of her deceased son, who was, my lord, kidnapped and killed by the executive.
As
And
per
As per
notification
notification dated 22 June 2004 and subsequent notification thereof.
you filed a writ petition earlier.
Yes, my lord.
Then what happened?
My lord, on the earlier round of litigation, my lord, this court directed the respondent to cause an inquiry, my lord. And thereafter, my lord, inquiry was called. And it was found that the Disaster Management Authority is not the authority to decide the claim of the petitioner. So thereafter, my lord, the petitioner approached before the district elementary education officer, in which the son of the petitioner was employed as a teacher. My lord, as per Annexure F, my lord, page 21.
Let us see the notification.
Notification, my lord.
Where is the notification? The entire basis is the notification and you are not doing it.
My lord, this is the subsequent notification, my lord. Right?
Your son.
Yes.
You are the government servant.
My son was a government servant. He
Then
was
how do you
serving
get
as
it?
a teacher.
Huh?
He was serving as a teacher.
But you are the government servant.
Yes.
Then how do you get the benefit as per this notification?
Yes, my lord. But
Yes,
disaster,
madam, there is a notification from finance department matter, which says that along with the paramilitary forces, those who are government employees, they can apply for under this notification matter.
Huh?
Under this notification finance matter. Political department and film department notification does not apply there. Clause 3 is the
it will only apply. Here he died out of how? How did he die?
My lord, he was kidnapped and further killed by the
No, kidnapped. Why? What? Were you discharging any duty at that point of time in relation to
no. In this regard, my lord, the police have given one certificate.
engaged in counter duty? When its notification will only apply at case the insurgency operates state or in connection with the discharge of so if they are in discharge of the duty also they will be assigned.
And committees of state government employees that and is also
Finally engaged the operating
yes, my
state. If it's kind of or in connection with the discharge of which as also the families of when so here you will get 5 lakhs.
to particular duties have to apply. The certificate has to apply.
The payment will be made by whom?
It has to be referred
Concerned department,
to the concerned department,
that is education,
education.
elementary.
Yes, we have a finance part.
But
BTC payment is made by whom? District administrator.
secretary,
No BTC here. BTC is a party.
Yes.
Finance is not a finance is there.
yes, my
Finance is also
but
party.
Yes, where's the finance department council?
But-
BTC is not a party.
Deputy commissioner is party, my lord.
Deputy commissioner is not. Here you are not there, no? No. Important, the learned council appearing on behalf of the district commissioner Kukraja had submitted on the basis of an instruction dated 1/2/2024 issued by the additional District commissioner Kukraja, wherein it has been entered that the Director of Education, Puruland Territorial Council, Kukraja, have been duly informed by the communication dated 31/1/2024 regarding ex gratia grants the next of the kin of the deceased person who were who was a state government employee and died in extremely violence and requested to verify the ex gratia amount to be sanctioned in favor of the person who is the next of the kin of the missing person, late Kula Prasad Kafle, AHL. To the said instruction, a notification of equipment dated 29/7/2006 have been included, wherein it has been mentioned that the families of state government employees, home guard, personnel of army and central paramilitary forces engaged in counter-insurgency operation in the state is still while on duty or in connection with the discharge of duty, as also the families of the drivers of the handset and other employees of the vehicles requisitioned by the competent authority to law and order and other emergency duty is ill due to attack of extremists or antisocial elements, and family of the state government employees ill due to hazardous nature of the duty shall be paid ex gratia grant of rupees 5 lakh if the death is due to extremist attack or during counter-insurgency operation, rupees 2 lakh for death due to attack of antisocial elements, it has also been mentioned that the state government employees engaged in hazardous operation in departments would be entitled to rupees 2 lakh for death due to hazardous nature of operation. The finance department, what do you say?
Thought that
Under such circumstances, this court directs Mr. A. Solia, the learned planning counsel appearing on behalf of the finance department, to apply to the court as to whether the petitioner herein would be entitled to, in terms with the office memorandum dated 29/7/2006. The instructions were placed by Ms. M. Borman is kept on record and not with the letter text. To this the matter again on 12th of February 2015.
I'm deeply obliged. Happy to look. The matter has become infectious. Matter has become infectious.
Infructuous,
Sorry.
Mr.
Assured.
And so the learned counsel appearing on behalf of the submit that the restitution has become infructuous in view of the fact why
Because of paucity of time, they have formed the new committee of the cooperative.
in view of the fact
Otherwise, the lordship, the board is of 2018. The term will get over by March 2025.
23.
24, March 2018-19, the board form. The 5 years term will get over by.
in view of the fact that why
They have formed a new committee.
in view of the fact that the respondents have formed a new committee. Taking into account the above, the instant restitution can close as it has become structured. In same order, if it
Completely.
Material also.
yeah,
So for which time may kindly be granted file the affidavit.
What?
Petitioner wants to file the affidavit.
affidavit of what affidavit?
For,
2018 affidavit in opposition and file, and now you want the time to file affidavit, 50,000 cost.
Lordship, the earlier
You
order,
are
Lordship,
obtaining, you are
directed,
enjoying a stay order.
Lordship, there is, Lordship, on the last occasion, Lordship was pleased to pass the order for impleading the Anu Kumar Singh against whom the order was passed by the respondent, Lordship.
Taking into account the orders by which he was treated of it. It made clear the right. It- it- You filed IA?
Lordship, for this I am praying before your Lordship, so for that I can be granted.
This
as the-
court made it clear that it has to be made clear such application has to be filed by 18/11/2023. What stopped you from filing it? We are in 2024.
Lordship, the regional manager was transferred to the head office, therefore the could not be filed.
Eh?
Only 2 weeks time may kindly be granted.
Cost?
Lordship, there is
10,000.
matter of Lord,
No. It has, otherwise it will be in violation of this court. On the last occasion also you took time on 15/11/2023.
order was passed on the 27/9/2020.
Mr. S.K. Agarwal, the learned counsel appearing on behalf of the petitioner, seek for a further accommodation for filing their application, seeking impleadment of Sri Anu Kumar Singh. So this court finds it relevant to take note of the order dated 27/9/2023, wherein it was made clear that the said application has to be filed within on or before 8/11/2023, failing which this court shall take up the writ petition for disposal, for final disposal on its merits. Full stop. Even after the time being granted, the petitioner did not file such application. Full stop. On the other hand, on 15/11/2023, the petitioner again sought for time. Today, the petitioner has again sought for time for filing application. For the end of justice, a final opportunity is given to the to submit file the application by 16th of February 2024 without pay. By the final opportunity to file the application on or before 16th of February, 23rd of February 2024. Full stop. This, however, could be subject to a cost to be deposited before the registry of an amount of rupees 10,000. Full stop. This the matter again on 4th of March.
Equivalent.
Martin,
Yes,
But the court that we have approved that petitioner might for it to settle that matter. As per the court, that date will be consent on that.
who didn't?
Well, the petitioner.
My lord, for the last occasion, they have given 32,000. And my lord, lease agreement was expired in the month of December 2012. My lord.
Hmm.
Now, only after passing of the order, my lord, they have approved.
and said that we will give you some amount which is as a area. From 2012, my lord, we approached the authorities time to time that we need the land.
Mr. Thakur kindly appreciate you take the you look into it. Report it. What about the equity?
The process, no,
Is
that is,
the profit?
that is equity.
And how much you are giving him now?
There are, as per the interest on equity for the primarily the advantages of processing credit not basically that have consented. Out of the 126 matter, one has not been consented for that equity.
One has not consented for equity.
That is it.
Then, madam, I think I need not further enlighten it to be clear
Yes.
of the here the consent is. You remember?
Yes.
This is for armed forces to come within the acceptance and the technique of the new. So, why do you need the consent? Consent is necessary for other purposes, but armed forces outside. It will not be for the armed forces. Why you are not starting the
So
Yes.
we have started, we have already started the.
Yes.
But till that, but other expenditure board directed keep some,
Yes.
agenda that, madam.
Yes.
And
Now,
accordingly, we
Mr.
have to.
Chaudhary,
Lord.
Put it the pattern.
The area
The effort that the AI of the responded authority needed that that approach the matter. However, the have the key the state. It's the authority that the public that people advise is climate. It's the matter again of 11th of March of on which day the learning council debate of the guys and that status of the initiative as well as also as whether there has been a negotiation settlement for change and prior to the for the Chaudhary, just one time, any negotiated it that put up and for the if I did the initiative of the it cannot yes, what is it matter about? He got the money.
Madam, actually, we have filed the affidavit, my lord, in paragraph 25, my lord, we have stated the page 6 of our paragraph. The land, my lord, acquired is, my lord, common land, not,
Huh?
only GDAP list has already submitted the common land, page 25, 6, page 20, paragraph 25.
What about the Virat?
That is it so much regarding it is there. It
Did they claim for Virat or the land?
Malab, they're only JRAT also, Malab. Page 24 of their affidavit, Malab, they have stated that 20, paragraph 24, page 9 of their restriction. Paragraph 24. They have stated that fictional Saxonia land as well as the government land have been acquired by the railway authority for construction of
So they had the house.
Malab. Houses JRAT.
So
So, Malab,
Uh,
that
it's not have to be paid the affected by the which does not address at whether there was any stuff, whether there was a on a of the but not the stuff. The of
all is there, Malab. This is there that has been submitted to Deputy Commissioner have stated
it okay, but you don't say anything.
throughout March.
Under such circumstances, the direct affected at whether any just have been determined and thereafter paid. Did the matter again on 15th of March of
Third.
55 by 11
Third of
Hmm?
Is a tech document, madam. Study next part. The water, all the next. There is no supply of madam. Woolen blanket.
take document
We have updated our affidavit.
and appears on behalf of the record that the officer of the court has also taken the third the Coco appearing out and the affidavit provided by the officer of the council wherein it has been that the state take document considering the above court and considering the above as not presented as dismissed.
Hello.
one which may be granted, madam. One which may be granted to
It is a matter about
regarding Malab, granting of profit margin.
Huh?
Profit margin is the fair price shop, Malab. Malab, page 23, Malab. The notification was issued.
oh, this matter is covered by the deputy judge.
Got it. Like, get the order to get another type of
Mr. Nayak, you were there in that matter that Joy Bora or that matter that fair price shop.
No, I was
There,
revenue.
there 50 plus.
I was I'm asking.
Or it's a, yes, we take it up at we take it up at
Lord,
But
Lord,
because he's coming from the other bank,
what is that?
then ask him to get that order because bank is covered by the different order that it was having yeah.
Right.
And the different process that they put the things
Lordship,
the case where state of earlier what was happening the price of software take up to the and the
South,
some transportation system was big
But-
and some part of the was the
Prepper,
now the government is here that it put the here they get the best of the best.
But-
And put right so the mobile to
what's
Right. each get that money there. They will remove.
they will say,
And the government says that the particular amount of money that as it,
Lordship,
so that was a phase that is big.
Lordship. He
So,
was telling me, my lord, I could not get the copies of the order.
you,
That's
you
okay.
just in fact I did it that the judgment of last 15 about getting out to the
Lordship, Lordship,
there's no challenge that it
Lordship.
is
maybe it. Lordship, okay.
Well, the petitioner has executed and completed the construction of a railway overbridge at Bongaigaon, North Salma, Tapaguri Road. Original value was 6,82,000 and odd. 6 to 82 lakh. Then it was revised value was 1532. And now the payment is not being made, my lord. They high retention, they said that sanction has been received. If you still see, my lord, they have replied to me at page 84, my lord. Work was completed in September 2009.
how much
I have to get, my lord, 8 lakh, 8 crore, 51 lakh and all. Since 2009, my lord, it's not been.
Eh?
My lord, they say, my lord, if you still see page 84, my lord, price estimate was given to us me. Now they say that sanction has not been received. Page 84. The first subject I have not informed you that the price estimate of rupees so was only submitted to higher certified office number so for sanction, but no sanction has been received till today. However, on this sanction, revised estimate, the balance amount will be initiated for payment. It may mention that as per revised estimate, balance amount is rupees 8 crore 1 lakh. Then again, my lord, they have written a letter. It appears to given a copy to me. That is at page 89. Page 89, my lord, your office side. Another letter has been issued by the executing letter to me in the that same. Now they have filed an affidavit, my lord, here.
but why you have not by the
My lord, they were that
they are effective they yes but the fact that they have not the device that Mr. Nayak. Your
Yes.
specific standing that they have not the device.
Yes.
So under such circumstances, the question of the direct does not arise. Cannot be it. Here, how that is because here and secondly, yes, yes, I was in fact I was how can
well, quantum merit,
case of it.
Well, on the basis of quantum merit, my lord.
Huh?
Quantum merit,
What the?
merit.
What?
My lord, that section 70 of the contract act, my lord.
But the
Thank you. Yes, sir, there, my lord. Because I have not, executed work on the bona fide, my lord, and they have utilized it. Not the,
your bona fide,
my lord. I'm just,
how does
because they have given me the estimate, my lord. Your loss is my just, my lord. It doesn't. So it is relied on by our High Court also in my paragraph 1819, my lord.
Huh?
1819. Oh, sorry, I'm sorry.
it's a case of two?
Maybe, my lord, there
So
was
may-
another judgment.
Yeah, in a writ petition, how can you decide what
My lord, your lawsuit, see, my lord, they have given the revised estimate also to me. My lord, on that basis, I have worked. My lord, yes,
Well-
it is there, my lord. Your lawsuit, see, my lord, that at page 24, that is a revised estimate.
44?
24. 24. They have given the estimate, my lord, then I have done the work.
Totally a certificate. How are you saying that if I
Sir, that was given to me, that on that basis, I have done the work.
No, no, no. It is subsequent.
and it's cookie the by the not the device
The approval is still not there. Document candidacy page 44. The work was completed. In fact, the bridge was inaugurated on 26/9/2008.
is
The
Railway overbridge.
With the petitioner has constructed.
it's
26/9/2008.
Yes.
So this certificate was issued 1 day prior to that day of inauguration. So I'm not on that, but the revised estimate was submitted only in the year 2010. That without approval of the revised estimate, Lordship, the work was done. That is one thought. And till now, Lordship, I'm waiting for the instruction. What happened to that revised proposal for revised estimate? Today morning, they informed me that they have already somehow managed to trace out the file. In doing so.
yes that's the top your client
At my land, and then that
financial constraint the big
Yeah. Correct.
The revised estimate on the basis of Lordship
Right.
price escalation.
no pricing from extra work.
Lordship. That judgment is there, Lordship. Simple judgment is there. Thereafter, Lordship, in other, I have seen judgment passed by other high court. I mean, admitting petition like this, money case.
Still money can
Yeah.
that to be money there is a thing that I have tried. I mean, the reason he can't go out there is that the year
That
I said,
19, my lord. No, my lord, because your lordship, my lord, they have said, they have issued a letter to me in 2017 that that page 84, my lord. The sanction is still pending.
That was the reply.
No.
Then again, my lord, 2000, page 89 also, my lord. My lord. Well, now they say that they have traced out the file and they're saying, my lord, wait, my lord. My learned friend has said that. Just trying to find out what is there in the file.
Going to help you.
My lord.
He's trying to help
Maybe, my lord,
otherwise, the case was
no, maybe, my lord, the file has been traced out. It maybe, my lord.
not wait. Yes. But that you are a it's not
But otherwise, also, if it is not approved by the authority.
but you want to go the after
My lord. Admitted. It is not admitted. Admitted in that sense, my lord.
like yeah, when they find a either
My lord.
case.
Yes.
But more than that,
Yes.
so the balance level, it, the equality of the right
But my lord, my work has been done, my lord. From their basis, my lord. I was given, my lord. Legitimate expression is also there, my lord. Legitimate expression is also there. My legitimate expression that as per their direction, my lord, on the system revised estimate, I have. That is
it
approval.
is not the truth.
No, approval is, my lord, their course, my lord. I am doing the work under the spending engineer acting India, my lord.
No,
And they
it,
is the acting engineer.
can the chart
Yes.
besides that
No, it is not my lord, that the activity engineer, my lord.
the legal legal
My lord, that I shall produce, my lord, who has, I shall produce, my lord, who has given me that.
it's an admitted fact that the
Quantum merit, my lord, that your losses is considered. Quantum merit, my lord, that.
very
And in the case, my lord, that your losses may allow.
they are
Anyway, my lord, you may be allowed to file it. You may be allowed to file it.
saying being aggrieved by the inaction on the part of the responsible in not making payment of the admitted contractual dues to the tune of rupees 8,1,43,439, along with interest at the rate of 18% from the date of completion of the work, that is 25/9/2008, till the payments are due made. For perusal of the materials of record, it reads that the petitioner was awarded the contract for construction of the radio completed Kumaina on North Kalmara Papaguti Road. The estimated value at which the contract was awarded, not the estimated, the value at which the contract was awarded was rupees 8,89,61,600. It is the case of a petitioner that that
My lord, that
at
is,
the time of, as on the date on which the petitioner completed the work, a certificate was issued by the executive engineer PWD. That is on 25/9 2008, that the revised estimate in respect to the construction of the work was 3 crores 82 lakh 85,439. It is under such circumstances the petitioner has claimed the amount of the fee. How are you getting 8 crores
My lord, it is 8 crore, my lord.
56? Have you got the original amount?
My lord, in the page 84 also, my lord, it has been mentioned. Because original amount has not been paid, my lord. Some amount is still lying. They have said that they are ready to pay that amount. From in the application.
Yes. Oh, wait.
Balance amount of 391.91 lakh.
Wait.
My lord,
It is the case for the case of the petitioner that though the executive engineer PWD has certified on 25/9/2008 that the revised estimated value was 50 lakh crores 80 lakh 85,439. But the state revised estimated value thereupon further increased to 50 crores 7 lakh 15,590, and thereupon further to rupees 50 crores 32 lakh 58,190. It is on the basis thereof the petitioner therefore claims that the petitioner is entitled to an amount of 8 crores 51 lakh 43,439. It is also the case of the petitioner that as on 29/6/2017, that is almost after another 9 years,
9.
9 years, the executive engineer PWD Bongaigaon Rural Growth Division had informed the petitioner that the revised estimate amounting to rupees 50 crores 7 lakh 15,594 has been submitted to the higher authority on 12/1/2010 for sanction, but no sanction has been achieved. It was mentioned that as per the revised estimate, the balance amount to be paid to the petitioner is rupees 8 crores 51 lakh 43,239. It is therefore the case of the petitioner that the petitioner is entitled to the same amount for which the instant petition has been filed. Pursuant to the filing of the instant petition on
My lord, 27
27/5/2019, this court had given notice by an order dated 6/6/2019. An affidavit in opposition has been filed by the editor. An affidavit in opposition has been filed by the editor PWD Road, stating in the area that the sanction estimate for the work in question was 889.516 lakh, and the construction work was done by both railway and the state deputy. It was further mentioned that the viaduct and the ROB portion was allotted to the petitioner at 6 crores 82 lakh 89,000. It is also stated in paragraph number 8 category that a revised estimate has been prepared and submitted to the higher authority on 12/1/2010, but no sanction is accorded till date. So the question of the balance amount to be payable to the petitioner on the basis of the revised estimate of rupees 15 crores 7 lakhs 15,594 does not arise. This court has duly heard the learned counsel's hearing on behalf
Well,
as
second
well
sub
as
para,
the
my lord. Para 8, the second sub para, my lord. They have said, my lord, this amount is pending, which they will pay. Because original amount is
was further mentioned that the contractor would be paid, the petitioner would be paid as per the accepted tender amount on receipt of the funds from the government as per the demand of the funds submitted by communication dated 2009 for the balance amount of rupees 391.91 lakh, which includes the price escalation as per tender clause 4.47 claimed by the contractor and which may be the base amount for further calculation. This court have duly heard the learned counsel appear on behalf of first party and have given anxious consideration to the submission domain. From the above materials on record, it reveals that an amount of 391.91 lakh have been admitted. Just look at
Subject to approval by the.
no,
original.
Lord, kindly see the certificate, Lord.
No, no, no.
25.
not the para 8.
What a balance amount.
So balance amount which it is on the air policy will be paid as per the accepted tender on the.
Yes.
So this is the tender. So 391.
It's not clear. Not clear.
Upon hearing the learned counsel appear on behalf of the parties and witnesses the petition and more particularly subpara more particularly to paragraph 8 of traffic the petition that the respondent parties have duly admitted that the petition must be paid as per the accepted tender amount on receipt of the fund as per demand of the fund submitted by office letter dated 2009 for the balance amount of 391.91 lakh, which includes the price escalation as per tender clause 7.2 claimed by the petition, which may be the base amount for further calculation. Under such circumstances, in respect to the amount of 391.91 lakh, as this court directs the respondent of court to make necessary verification and make payment of the same, and upon verification, it is found that the petitioner is entitled to the same amount or any part thereof, the same be paid within the from the date of the from the date a certified copy of the instant order. However, as regards the amount which the petitioner had claimed on the basis of the revised estimate, it is the opinion of the court that the statement having not been approved by the authority, that the opinion of that the state having not been approved, that the revised estimate has not not been approved by the higher authority, who as per the tender condition, would have revised the estimate. It is the opinion of this court that no writ can be issued under such circumstances. However, this court grants the liberty of king to evade such remedies as available under law before the competence of the court for edification of its claim in respect to on the basis on the revised estimate. This court also have taken note of that. The court also have taken that the petitioner have been pursuing extensively before the bona fide and as such, the period of the petition from the date of filing of the petition date be excluded while completing the of the petition if the petition filed revised.
In this case, your lordship has directed me to obtain certain instructions.
That part
Yes, lordship, that revenue. And lordship, they are making some prayer, lordship, for grant some more time to them, lordship.
Bye.
Because the circle officer, lordship, he was also engaged in some correction of publication of electoral roll. But in addition to that, lordship, I have lordship, no, lordship, publication of notice. Understand is also entrusted the responsibility of ERO of Dispur LSC for publication of electoral roll. ERO of Dispur LSC, but even then, lordship, I have, if your lordship go by the order of your lordship's order at page, sorry, dated 28/19/2019 of this honorable court, lordship, 19, whereby an interim order was passed. Pursuant to this interim order, we have received earlier and certain instructions. Whereby it was stated that because of that interim order, lordship, the demarcation proceeding was temporarily stayed, and that interim order is still there. So because of that, most probably I have a conversation with the circle officer. He is also unable to state me in details, lordship, but according to him also that proceeding is still pending, the demarcation proceeding, because of this interim order. But even then, lordship, they are praying for some time, lord. Mutation case. Lord. So they are praying for 15 days time, lordship.
For what? For getting an interest.
Yes,
2 o'clock.
it's the prosecution.
2 o'clock. What is the date of petition application? If they are not voted for this. On date 2024, I have asked that. Yes.
17, 18,
Because that's what the statement.
17, 18, 17. Regarding the demarcation, lordship, your
Well,
lordship,
but the demarcation,
Lord. Lord.
I've only asked the day the project to have filed it. We have not.
17.
They cannot jump into the question of departing the
Correction of report.
because once their name is mutated of the key, it is not right that because the question
Lordship, I will try to get.
is the matter again.
Ninth or 12th, my lord. Ninth I will not be 12th.
Right? And not it, it,
Lord.
further that also that it take it not it I that it 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 what it that what I paid I it I it paid it paid for first appearance the district commission. Yes, madam.
Lordship, is that matter where the amount was admitted. And
Oh,
then
yeah.
there-
I have a proposition, my lord, since nothing is a dispute. And my lord, since that is admitted, my lord will dispose this matter. my lord.
no, again, you admit the interest. Admit the interest, make the
Everything has
payment.
been admitted by this fellow in the MSME council. There's a slight difference of
Have you
amount.
got that ticket?
We have it, Lordship.
You got that amount?
No, Lordship, we have not got
Well,
anything. No,
So that's the
Nothing.
reason I was asking my lord to dispose this
28
matter.
can yes, I remember.
no,
Okay,
I have not, I've not got
However,
that.
taking the admitted the way that the case it's like that is but
Yes.
because
No, efforts are on, my lord. So let them face their matter. But this can be disposed of.
don't
because there's no
worry.
case, my lord.
No,
it's the cocoa there's no problem of that. It was it was like
But-
why thereafter then
And very well, my lord will issue contempt. Contempt. Then they can act. I have
this court by
spoken
the
over.
order dated 27/9/2023 had directed the commissioner and secretary to the PhD department to disburse the amount of rupees 28,80,804 to the petitioner on or before 22/11/2023. However, the said amount has not been paid. When the matter was listed before this court on 22/11/2023, the counsel appearing on behalf of the PhD department submits that half more time is required for the purpose of making the said payment. And as such, this court had granted the last chance to the commissioner and secretary to the government of Assam PhD to disburse the amount to the as directed by order dated 27/9/2023, fixing 13/12/2023. When the matter was listed before this court on 13/12/2023, it was submitted by Mr. K.P. Pathak, the learned standing counsel of the PhD department, that the personal appearance of the Commissioner and Secretary to the Government of Assam PHE Department be deferred for a period of 2 weeks in order to enable him to take all necessary steps from his end for compliance of the direction regarding disbursement of the amount to the. Today, when the matter has been taken up, Mr. D. Gogoi, the learned counsel, appearing on behalf of the PhD department, submits that the PhD department, in spite of specific directions, have not paid the said amount. He submitted that the matter may be directed, disposed of, and if the PhD department fails to make the payment, necessary contempt proceedings may be initiated by the petitioner. This court is of the opinion that as on the face of it, the orders passed by this court have been defied with impunity, and in such circumstances, before initiating appropriate contempt proceedings, this court would hear the Commissioner and Secretary to the Government of Assam PhD department personally. Accordingly, this court fixes the matter on 12th of February 2024
Can it
at
can it be on the 15th?
In that case, my lord, I may be allowed to rely on the documents are there. Wherein, my lord, efforts were on, the approval, administrative approval of the fund had lapsed. So we have moved the finance department.
15th of February.
16th of February.
16th of February. This
Madam,
subject-
if you don't want, if you have
I'm
any problem out there, let this matter come up before any other court.
No, Shiva, I'm sorry.
And for a senior counsel, is it the requirement that you have to prepare to get opinion?
Okay.
So in that case, my lord, they
16th.
my lord, apart from
16th.
my lord,
Taken
personal
up on
appearance, my lord,
16th at 10:15 a.m. through video link to be provided by the counsel appearing on behalf. It is made clear that if the person concerned, if the Commissioner and Secretary to the Government of Assam PhD department fails to appear at 10:15 a.m. through video link, he shall be personally present at 2 p.m. before this court. It is, however, made clear that in the meantime, if the amount has already been disbursed to the petitioner, the personal appearance, the directions for personal appearance need not be complied.
my lord, just a second. Commissioner Secretary slash my lord, Special Secretary. There are some details in the file.
Absolutely no. I have directed Commissioner and Secretary, that's all.
That person, my lord, may be not.
Commissioner and Secretary, I am not
Secretary is there.
concerned. If there is nothing out there, we'll see. Because this is what you have taken. Then I'll initiate contempt on you on the next occasion. Yes, you appear. You said Commissioner and Secretary.
Right.
So if none appears, then you don't worry.
My lord. 16, my lord. Very good.
Yes. What are these matters?
Number.
They were asking for some adjournment.
Yes, lord.
I fixed the matter for final disposal on 14/9 today. Yes, Mr. Chaudhary. This could fix the matter on 14/9. But the matter came up.
But now,
See? 14/9 or 363. Not alcohol and explanation from the rate. Yes, what is this matter about?
it is to be termination of the contract.
Is it stay?
No, there's no
Then have you taken the money? Risk and cost? No.
risk. About they have found the security that has been fraud.
And why do you have filed a contempt?
But there was an order like that. This is 20th of October 2020. It's W3900.
Which order?
Order dated the 20th of October 20.
20?
20th of October 2020 in the W3900.
Yes.
Because of this order, the content was filed and
With instructions to
Right, then
ensure
I-
he has submitted that in respect to the query as made by the Imam, he has received instructions from staff by stating that total account has been restricted only for participating here, that the contractor will not be able to participate in the future and same stretch from the date of the holiday. Now this 3 years is over.
Hello?
Blacklisting is over now
Blacklisting period is over.
because it was 3 years.
That's it.
The above action shall not prevent the contractor in any way to withdraw their payments from the IOCL. They are free to carry out their ongoing work and to receive payments for other work. You are not. Now there was must have been something you have done. You stop.
No, my God, after this, we filed this IA saying that that statement based on the content of the file. That was with regard to that payment in respect of the other things. But so far as the risk and cost is concerned, that is a different aspect. And therefore, it would be effective.
So now therefore we do one bit. As he is not there, we have it on a particular date. When we want.
Secretary of
In fact, Mr. Chaudhary, yesterday we were sitting in a full bench on the question as to whether Article 260 is directory or mandatory. There was a two division bench judgment. It was made a reference to a ticket. We have requested you to be the amicus in that matter, taking into account that this is a matter pertaining to Nagaland. And in Nagaland is a different thing, but the thing is, it would be very difficult for those councils. But the point of law is there. It is only that point of law. So we have requested you to be the amicus along with that you are at liberty to choose a junior of the USA.
And before the time,
Matter is 6 on 8 February at 3:30. So we will matter when. There's no urgency.
whereas we have to set certain purposes, we may have urgency.
You don't have urgency.
6 on 13.
30.
1 13.
This the matter is 19th of March 2024 at the request of the law. So that an attempt can be made to dispose of the petition.
CP of that.
Section 91 of the statute. And what type of deposit?
You have not deposited.
No.
Why?
Get what the declaration of the
What declaration?
under section 91
91 of what?
of 2013. Sir.
See, here is the case whether you have already, there is already a direction out here. There is already a sanction.
That on section 721.
Huh?
It's 13, my lord. The additional.
Yes,
So the deputy commissioner has not visited. In fact, Lord, there is a decrease from
now what has happened to the acquisition?
for
Because you see, whatever may be, the problem arises with these type of orders for seeking compliance. There is a direction passed by this court to the effect, with due respect, that this payment has to be made in respect to the additional 261 bighas of land. Now, how can that payment be made without an acquisition? As on the date of the order, the land was never acquired, although possession was taken. The different thing, the possession was taken without following the due process. It is another aspect of the matter. But where is the question of making payment if there is no acquisition? Now, what is the status of the acquisition proceeding? Now, this therefore takes a different turn. The amount has been duly sanctioned by the government.
policy.
But the question is, can you make the payment without an award? Or if you want to do it, you are to therefore exercise the powers of emergency. Are you going to do the emergency exercise? Urgent need?
Well, the instructions received is that already they have surveyed the amount and asked the defense authorities to deposit the account. But they have not deposited and subsequently from their side, they have
So,
again assessed.
all these things are understood, but you have to look into it. If it is done under 2013 Act, it has to be preceded by a notification under Section 11. Have you done that?
Process has been done, and in fact, I have got the
It is not a question of this process or no process. Simple thing is, like the Section 4 notification, which was mandatory for acquisition. Under the 2013 Act, it is Section 11.
Ma-
Have you done that?
Section 19(1) declaration they have issued.
So that means they have already done that.
Yes.
So 19(1), it is like a declaration which is terms of Section 6. So under such circumstances, then thereafter, what have you done?
Correct.
You have to pass the law.
So the declaration, in fact, what I have found in 2018, they have requested them to release them. They ultimately, because of the inspection from their side, from our side, some time has been elapsed. On 2nd of February 2024, that is yesterday, the declaration has been issued and it is sent. Now, my lord, they have communicated to us that after the declaration only, we will deposit money is with them. They will give the money.
So you knew that the matter is coming up. So you yesterday,
No, in fact,
otherwise what?
it was under.
Yesterday they have issued a declaration and today they have sent the notice to the defense, madam, to deposit.
Better.
Not
Better have it 12th of February. Image. Okay. 16th of February. This is the matter on 16th of February 2006, on which day the counsel appearing on behalf of the respondent for 1 and 2 shall apprise the court as to whether the amount has been duly deposited in the has been duly disbursed to the Deputy District Commissioner, Kamrup, pursuant to the declaration so made on 2/2/2024, passed made by the collector. Pursuant to the declaration made on 2 under Section 19 of the Assam of the right to fair.
But can this be on 15th or after? On 15th or 30th?
Report of
Obliged.
See, Mr. Nath, there are two aspects. One is the contempt proceedings, one is the question of compliance, and the other is the question of punishment. For the purpose of punishing, you need to make that person a part because you have to issue notice. For the purpose of compliance is between me, he has no role. Therefore, these let us first get into the point. Keeping it on fourth because of the fact that because unnecessarily if it goes out, you won't get any money. Again, the matter with but it,
Obliged.
oh yes, this matter, if you remember, you were between that matter, not 50 plus and 1.
50, right.
If I remember, in that matter, I had in my judgment duly taken note of that there was a challenge to this 143, you see, 143 rupees.
Yes.
to enhance the rate of profit area for it. 15. Now, pursuant thereto, the decision was taken that this is this one entire 143 rupees now would be given to the
Fair-
fair price shop.
fair.
So what remains now?
But in fact, this has been implemented, and now the fair price shop, they are getting the 143.
143. So nothing remains in this.
They have challenged the notification.
No, they have challenged this notification of 2016. It's okay. But now, it was where you have made the bifurcation.
Yes.
That 40 to
70%,
143, of which
70
70% would go to the fair price
Fair.
and 30% to the transporting agency, the Samavai Committee.
TPSS for the
Yeah. Now, thereupon, you have made a decision out here that entire thing will be given,
will go to them.
and for which the government had made a corpus from its own
Yes.
to pay to the cooperative society. So
Corporate-
under such circumstances, I think nothing remains in this.
Here, nothing is to be, nothing remains to us, and that effort for transportation from tier 1, tier 2, that is separate process as separate. That is a separate from FCI Godown to the Godown of the CSS, and from CSS Godown to the fair price. We call it tier 1 and tier 2. That is a separate thing for government has taken
That is rules. There's a rules frame, no?
2015.
2015. These rules makes it very clear.
Clear.
So now, in view of your subsequent decision,
Yes.
by which you are now giving total 143 rupees out there, nothing survives in,
Nothing. That is, but
because if I remember, yeah, it was judgment. I think that judgment
Vijay, yes.
I think it-
Vijay, 5570 5470 5470 please.
Huh? No, no, no. That judgment court is
Yes. Five four seven zero 2020.
It was delivered, but I mean,
Well, the para 17 of your docket, sir. Para 17 of the judgment, sir. Five.
it was
It was on 22nd of December 22/12. Para 17 of the
5470,
547, 2020.
5470, huh?
Yes. Paragraph 17 of the judgment. Because noted rule 7 there. I have paragraph 17. Thank you. 17, 30, 33. Rule, sir.
Yep.
33 of para 30. Yes. But I have a copy of the cabinet. Cabinet. Yes, it's not taken.
And that was pursuant to a division bench order.
But in fact, that has been after this court, and they went on appeal. That appeal is no, no. This appeal, no, no. This the other
What happened?
the appeal filed against this doesn't
Hmm.
this doesn't have Or I'm referring to the judgment where the decision of the government in appointing tier 1 and tier 2 that has been that deputy judge. This is no connection to. And kindly come to para 47. Para 47.
It, and how to, you have taken the decision of 140
Yes.
to give it. So nothing remains.
Okay.
The institute has appeared on behalf of the petitioner in court. The TNR, the learned counsel, appears on behalf of the learned senior government advocate, appears on behalf of the instant restitution has been by challenging the notification dated 23/2016, whereby the whereby it was stipulated that there would be enhancement of the rate of profit market of the GSS of the society NFP stopped at rupees 143 per quintal in the ratio of 730. That is rupees 100.10 per quintal to the FP stock and rupees 42.90 per quintal to GTSS Cooperative Society bracket close, with effect from 1st of December 2015. It has been brought to the attention of this court by the learned senior government advocate that this decision, this notification no longer exists, inasmuch as the government of Assam through a cabinet decision had taken through a cabinet decision had granted the benefit of the entire fund to the fair price shops, and which is now being followed. So, taking into account the above, this court therefore dismisses the instant petition as it had become instructed.
55.
Yes. Government council.
My lord,
Tell me.
My lord, the matter is resolved. My lord, notification has come out, my lord. For the whole of PTC. It is taken care of.
It's the the learned council appearing for which one now?
Board and Territorial Council here, my lord.
Appearing on
Welfare-
behalf of the Boroland Territorial Council Department of the Government of Assam. Submitted that 29th of January 2015 by the governor of exercise of the deputy deputed 2000 for whereby various elected activities have been within they are reputed to dispose of the state route. So the said investigation has been placed for court during the course of the hearing. It is kept on record and taking into account the above, this court therefore is of the opinion that nothing further is survived for edification of the incident, and accordingly, the repetition stands.
Direction to the.
And if they have anything, well, they can raise it here.
Lordship, to address the delay part, the direction to the petitioner for approaching the appropriate office.
Why should I give a that? You know, now it has
Because there is a delay, so just to address the delay part.
the court, however, finds that as the PTC election tribunals have been constituted only on 29/1 by the notification dated 29/1/2024, the petitioner will be well advised to take appropriate steps. Yes,
Lordship, the matter might have become instructive, but we are not able to contact the client. A short period might,
you are not,
we're not able to contact the client.
so that makes the repetition infructuous.
No, Lordship, as per their affidavit, they have filed.
Yes,
They-
what is it?
They are agreed by a circular, they are agreed by a circular, by the NFL of asking the Jorhat division of the railways to work 24/7. There is loading and unloading of goods. And the main allegations were that the facilities provided by the railways were not up to date. So they are scared they not. While my affidavit is that when 2021, everything has been completed, all the requirements have been met.
Para 21.
So, my lord, in the year April 2001, my lord, all the works have been done.
The court having heard me,
HG.
joined to the learned counsel appearing on behalf of Mr. A. Bokoto appears on behalf of the respondent of the court. So the grievance of the petitioner here is
Circular dated by the 25/11.
is challenging the circular dated, and the petitioner herein have challenged the circular dated 25/11/2020 on the ground that the state circular is arbitrary, illegal, and violated of Article 15, 916 of the 19(1)(g), 21 and 300A of the Constitution. And also the respondents have duly filed an affidavit in opposition stating inter alia where that
The renovation and upgradation of the goods yard were completed 4/10/2021 and it was open for the public to use from 5/10/2021.
that the
All the grievances have been met.
infrastructural development work have already been completed on 4/10/2021, which include a complete replacement of the old damaged AC sheet roofing of the JT Goods Office, licensed porter roof and merchant roof. New tiles have been provided on the floors of the goods office, the labor room and the merchant roof for a longer haul of the said premise. Aluminum windows with proper grills have also been provided, replacing the earlier old window. And quarter stone flooring have also been done at the floor and the back verandas of the goods office. The goods office toilets have also undergone a drastic makeover and the toilet has been renovated with new flooring and walls, as well as new hand wash machine, etc., to the benefit of the labor. It was also mentioned that all the earlier old and defective shutters of the goods godown have been replaced, and individual water tanks have been provided to avoid any disruption in the service of the water supply to the toilets, bathrooms, urinals, etc. Taking into account the said affidavit was filed on 19th of May 2022. When a matter was listed on 17/11/2023, this court had put a specific question to the response to the learned counsel appearing on behalf of the petition as to whether the grievance of the petitioner have been duly addressed to, taking into account that the infrastructure and development works having been completed. On the same date, the learned counsel for the petitioner sought for an opportunity for the purpose of filing a rejoinder affidavit. However, no such affidavit has been filed. Taking into account that the statements made in the affidavit in opposition have not been denied, in spite of receiving the said affidavit as far back in the month of May 2022. This court is of the opinion that the grievance of the petitioner have been duly addressed to by the development and infrastructural development works. So, as such, nothing further remains to be adjudicated in the instant petition for which the petition stands. The rest came to
May your lordship. Lordship, the youngest learned counsel, Mr. Kadhajika, is out of station, my lord, to look
Very well.
after the arrangement of his son's marriage, my lord. My lord, to look after the arrangement of his son's marriage.
What?
My lord, the son of Mr. Kadhajika, my lord, is getting married, my lord. So,
Oh.
so, my lord, at least 3 weeks time may be given.
We already, when I communicated about no instruction has been received. What matter is regarding matter the effective. But
That's a public matter.
No.
What happened? There's no stay. What is that?
No, my lord, they are occupying, my lord, the government land and cultivated the petty. They are occupying, my lord, the government land and cultivated the petty. They have asked the mother that the government has asked mother to vacate that their state there, which are already been allotted to the some other institution. The government.
How can you think that Assam public if it is the government?
Well, look, in the notice, mother, it was not mentioned under notice. Lord, may kindly goes to page 95 next time. Well, look, that Lord, may kindly peru about that next page 97 and next and this land hand bill allotted to the some other institution by the land advisory committee on 29/12/2018.
When further minor instructions on the awaited, we are talking.
But the instruction is awaited, that is a part of the decision filed in the year 2021.
21.
But the
It was
instruction,
noted
you
that
have not given any instruction.
we already been communicated, my lord, that no instruction has been issued.
They are not giving any instruction.
Nothing. Okay. After notice of motion, my lord,
The initial petition has been filed by the petition. With the grievance that the respondent authorities are trying to evict the petitioner from the land belonging to the petitioner. This court, by an order dated 2022, had noticed and had also made it clear that the interim petition be considered after instructions are received from the state. Up to 2 years have passed by, but till date, no instructions have been received. Under such circumstances, court fixed the matter again on 12th of February 2024, on which date the circle of the Gosaigaon Revenue Circle shall apprise this court as to why the notice dated 9/1/2020 was issued, and as to whether there is any further action taken against the petitioner. Yes,
It is related to Bharat allotment of minor petrol pump by the Bharat Petroleum Corporation Limited, matter. BPCL, my lord.
And?
In the year 2018, my lord. The petitioner, my lord, he was selected and was given as per the order dated, my lord, 30th January 2020, my lord,
where?
at page 18. At page 18. Here, my lord, let us like.
Yes, yes.
Therefore, he was successful, my lord, in draw of loss, my lord, conducted on 29. And he was asked to bring, and security money of 30,000 was also deposited by him, as per my lord, the letter dated 30th January 2020 at page 19, my lord.
Then what happened?
After that, my lord, in the online, my lord, application was submitted by him, and on before 24th of January, my lord, 2018, and at that time, my lord, everything had to be mentioned, my lord, online. So even land details also had to be mentioned. So my lord, land details and dates have been mentioned, my lord, there. But at the time of, my lord, the documents as per a letter dated 30th January, my lord, the documents of lands, my lord, the affidavit was to be submitted on 2 lands were given, my lord, because it was in the order right hand side of the my lord, there is a specific area mentioned in the advertisement
Page?
also. Fine. My lord, as page 19, my lord, all the documents were to be submitted, my lord,
Yeah.
all the documents. Then, my lord, in the right hand side, it was,
What type of land did you give?
my lord, as per their, my lord, as
No,
per their
no,
wish,
you
my lord.
tell me. First
Yes.
of all, you say these type of matters, there are three types of land.
Yes.
One belonging to you.
This is on lease, ma'am. On lease. That
Number
is why
two is
affidavit. No objection.
leased out.
Okay.
Number two is leased out.
Yes, ma'am.
Leased out for a particular period,
Yes.
19 years or something.
Yes.
And the third is you can give of the family, but subject to certain documents being
Yes.
given. Now, what land did you get?
Lease. ma'am.
Now, is the lease deed registered?
Pilot, lease. Obviously, my affidavit has
No,
asked to give
affidavit.
me.
Lease deed has been registered.
That is not the
That is the
But that is not the
page
issue.
26, my lord.
page.
26.
My lord, I
Is the
rejected,
page
my
that
lord.
when you have however, it has been observed that that the documents submitted are not valid for saying that that document was executed and
The tag numbers were, my lord, wrong. Only on that point, my lord. Whereas, my lord, I had given 2 documents within time. my lord.
Hmm.
And they should have accepted one of them, my lord.
No. This tag number 159 is whose land?
That is also leased, my lord.
Show me the lease deed.
Not leased it, my lord. Affidavit was asked, my lord.
No. You must be having a lease deed.
Not exactly leased it, my lord. There should be no objections, my lord. My lord,
No. If it is
criteria
a
may be
lease,
same,
it
my lord.
has to be a lease deed has to be there, which is registered.
But
that
that
is
is
the
not
law.
supposed to be submitted, my lord.
Huh?
My lord, kindly, my lord.
Okay. Take to vacate.
Here, here are the.
Why did you reject?
Can you see, my
See.
lord, page, my lord, 27, my lord.
27.
It's submitted, my lord, documents of another land, my lord. Which was not mentioned in the online application.
Where is her application? You have not filed your
I
affidavit.
have the record, my lord.
You don't need to file an affidavit.
So kindly sit for a moment, my lord. Can you turn over to the second page, my lord?
Eight. Land document.
Yes. Clause 13, my lord.
Pullin Hendik.
Yes.
No relationship.
Yes.
Registered lease deed. It's a registered lease deed.
No, my lord. He has to be submitted in the form of a affidavit. Thereafter, it is required my scheme, my lord. So after that, my
Date
lord,
of registration of the sale deed is deed. Registered lease deed. Date of mutation. Where is the registered lease deed?
that is not required, my lord, because it is a my lord was KFS, my lord, scheme, my lord. After my lord, my LOI, my lord, the detail end, my lord, the option on my lord. But if you don't leave it, there's a problem of affidavit.
Where?
That is also repeated page 22 of the minute repeat summary. Yes, submitted minute and affidavit by one my lord. Sunwal.
Sunwal.
Page 20. But yes, submitted one affidavit my lord by one my Dhanendra Sunwal,
Dhanendra Sunwal.
which was not my lord mentioned in the online application. It mentioned the police handpick my.
Even Hen-
Have you seen the detail?
Yes, I have.
What does it say? If you want to be a group two, what does
Total land owned by third party in part of full.
group one?
Open it registered.
So
the voucher has been my lord, voucher has been annexed, my lord. At page 32. my lord.
Total my lord, page 5 my lord.
Page?
Internal page my lord. Page 5 my lord, land my. The page number is bottom my lord, page 5.
Yeah,
Land.
group one, applicants having suitable piece of land in the advertised location, area, either by way of ownership, long-term lease for a period of 19 years, 11 months, or advertised by the OMC.
Yes.
Group two, applicants having firm offer for suitable piece of land for purchase or long-term lease for a period of 19 years. This is a suitable offer.
Yes.
Now, there was none from group one.
No.
So,
He applied for group two.
no. So, none from group one. Only there was somebody from group two. So therefore, the draw of lot was amongst the group.
So what is the document, madam?
How many people have applied for group?
I don't have it. But madam, the document, madam, that is file, madam. That is, madam, page, madam, 6, madam, kindly see, madam. Because they have my.
Yeah.
So, group two applicant has the farm offer of the land with to the land offered contract. But contract is that for transfer of the offered data in the form of a certificate. Yes, sir. Certificate.
Which one?
Clause F.
The land
Clause.
owned by family members will also be
No, madam,
considered
clause F, madam.
Huh?
Clause F, madam.
F.
Yes.
The firm offer where will include land offered from third party based on agreement to purchase these shares as per the terms and conditions of the offered letter to be along with documents mentioned in clause D. Yeah. Above, to establish the ownership of the land offered. Now, was that document
No,
placed?
madam. He was submitted, madam, one minute affidavit of one minute.
Understood.
Yes.
But along with that, whether that document was submitted,
No, madam.
that person has ownership.
Yes, sir.
Okay. Yes, madam. Go to the case.
My lord, as per the requirement of the IOC, my lord, we had filed affidavits on. There is a stroke, my lord.
No,
Affidavit
not
stroke,
only
my lord.
affidavit, that document, that person has the ownership. Did you enclose? Can
But
you
it-
see F?
My lord, it was not triggered. Otherwise, I would have been rejected straight away, my lord.
No,
At the time of filing documents, my lord.
no. At that point of time, they don't make that scrutiny. The scrutiny is made subsequently.
My lord, I have been rejected only on that point, my lord, that I have mentioned something in the tag number, pata number was wrong. And at the time of mentioning
Is the
online,
person different also?
my lord,
Is the person also different?
my lord,
The person who signed the affidavit,
yes, my lord,
whose affidavit you have placed,
Yes.
is it the same person whose affidavit, whose
he is
different
same
land?
person, my lord. Two documents I have filed,
Huh?
but at
No,
the
my lord.
time,
That's also
there are
different.
two
Yes, madam.
persons,
Can
my
you see,
lord.
madam, the online application, madam? Is mentioned one, madam, name, madam,
Yes.
only Henrik, madam.
Hmm.
Yes,
Now
Yeah,
the
what
document is
affidavit is-
submitted by, madam, one, madam, Dharendra Sunwal, madam.
no, I have filed two
Dharendra
Online
affidavits,
application,
my
he
lord.
mentioned about the madam, name of Pauline Henrik, madam, which is
Yeah.
expected to file. After he got
Application says
selected.
about dark number so and so.
Yes,
So
sir.
this affidavit was not a part of it.
No, madam. He has filed under affidavit of one, madam, Dharendra Sunwal,
That was done subsequently.
subsequently, madam.
Subsequent means, my lord, at the time, within
That is
the
the
time
discrepancy,
limit,
my
my lord, within 24/12, I was supposed to file all the documents
So
as
then
per
you have
their
to
instruction,
submit
my
a
lord.
fresh application.
No, madam. Madam, kindly see, madam, so in an online application, madam, there's a clause, madam. After the state piece of plot of land, eight online application, that expert.
Yes.
Now, after madam, fully handic, madam. The said piece of plot belonging to fully handic has been offered to me as for putting our retail outer of the Alpumpa Bharat Petroleum Social Community above is being given as farm offer and is for purchase long-term lease for a period of minimum 90 days, 11 months as advertised by the oil company Bharat Petroleum Corporation. That as per the document and a report from advocate. So the report is also for different person. Available with me
That
as
report was given.
yes, madam.
Advocate's report.
Yes, madam. See, madam, the report, madam, indicates, madam, the name of madam, the Dharendra Sunwal, madam.
Oh, he has given the report of what?
The honor's name is Dharendra Sunwal, madam.
The signature of the advocate is,
Yes, sir.
it is to inform that I have perused the document sequence of tax number sequence who had applied for retail ownership of Bharat Petroleum for the location of sequence. This is okay. So there is
Like in the online application, the tag number is 159, pata number 1, my lord. And the affidavit, my lord, which was sent by the candidate, my lord, was the tag number, my lord, 30, 220, periodic pata 30.
And it
Because
handy,
when after got selected in the
affidavit
job,
by
lot, they
handy
submit
also, my lord,
a
twice.
document,
Hmm.
which is mentioned in the online application. That is the requirement, my lord.
that is required.
That was not done, my lord. That's why, my lord, during my lord, quickly, it was my lord, found my lord. That's why he was placed in group 3, my lord.
Group 3.
Yes.
Now he was placed in group 3, my lord.
Group three.
Now
my
there is no group 2. Is there anybody
He
in
is
group 2?
rejected as
No.
group two, my lord.
Yes, but there may be some group 2 that the veto will be conducted within
So
group 2.
if it is there, you have
Group-
to again redo the
Yes, sir.
problem.
Amongst the group 2 candidates. Sir.
But I am placed at in group 3, my lord, because of the wrong tag number, my lord. Otherwise, my lord, documents have been filed within the stipulated time. 2 affidavits, my lord, I have filed on as documents on land. Because both the lands, my lord, on the side of the right side and the left side of the highway, my lord. So that was the confusion, my lord. Otherwise, both lands are genuine, my lord.
Then why didn't you give the certificate affidavit of that person?
Yes, sir. Now in the pleadings, my lord, it actually it's a mistake, my lord.
Yeah,
It's
that
amongst
was
the
my
application, my
mistake.
lord. Because in the online application there. it
Because
mentioned to
this,
the, my lord,
the tag number mentioned in the
Undertake.
on online, my lord, that was on
Undertake,
the left hand
whatever-
side of the highway, my
kindly
lord.
see clause 15 of the online application. my lord. He has to give an undertaking, my lord.
No, but apart from that, most important thing, you see this F, you are to enclose the document. Without enclosing the document, how can you do it? See, there are two things. Either you have to bring on record the original sale deed, or you have to mention. That is why it is mentioned out here. Kindly see this. Date of registration of the sale deed, if deed, in that application itself. Date of registration of the sale deed, if deed, registered lease deed, oblique date of mutation. The date of mutation has been put at 21/12/2018. The problem arises, Mr. Bottakot,
Yes, my lord.
is that you have not filed your affidavit. And you have taken a,
Proper.
we'll go on the question of doctrine of non-traverse. Why haven't you filed your affidavit? Okay, tomorrow, file your affidavit.
By Tuesday, my lord.
The incident matter cannot be adjudicated upon without Mr. S. Bottakot, the learned counsel appearing on behalf of the IOC,
PP, sir.
Huh?
PP, sir.
BPCS, had placed before this court various documents as well as various documents and have also made his submission. However, those documents are not part of the record. It is also seen that no affidavit has been filed, although there is an interim order operating from 9/8/2021. It reflects very poorly upon the respondent BPCS, respondent Bharat Petroleum respondent
When
authorities. in not filing the affidavit. More so when they are a public sector undertaking. Mr. S. Bhottakur submits that a final opportunity may be granted to the petitioner, to the respondent, for filing the affidavit. This is the matter on 16th of February 2023. The affidavit be filed by 9th of February 2024. The petitioner, if so advised, would be at liberty to file the reply now before 15th of February. 29th, you bring this thing on record. Yes.
It is a
Hmm.
This is about the appointment of an MMR, a selection process for appointment of Muslim marriage registrar, my lord, by carving out cases from within my jurisdiction. My lord may come to page 39.
Yes.
This is an instruction from the Inspector General of Registration to the District Registrar Karimganj. May I read? With reference to the subject cited above, I am directed to state that the Permanent Committee for Selection of MMR in the state of Assam and its meeting held on 7/10/2020 at and 6/11/2020 recommended for appointment of a permanent MMR at Jarapata and Latu PICP. PICP is Park Infiltration Check Post under Karimganj district. Therefore, you are therefore requested to initiate the process of interview to local advertisement for selection of Muslim marriage registrar at Jarapata and Latu PICP areas under Karimganj district as per this. My lord, I am aggrieved by this and the subsequent advertisement.
What? Your area has been reduced.
Yes, my lord, the power to reduce any area or to demarcate any area is on the here the government has not. In fact, they have filed an affidavit stating that it is not within their knowledge. My lord, after this letter, my lord,
Who said?
the government in their affidavit.
Government who?
My lord, there is an affidavit in opposition, my lord, page 73 onwards. If my lord comes
By
to
the respondent number 1.
respondent number 1.
What do they say?
My lord may come to para 5, page
The
74.
basis of the viability report submitted by the
Para 5 was an initial, my lord,
So, without the revenue and disaster management doing it,
Right.
if they reject it,
the district registrar could not have done.
have neither modifying the license of Hafiz Iman, you are Hafiz,
I am Hafiz
Hafiz
Mohammed
Chaudhary,
Dastur.
MLA of Karimganj, not cancelled the. Who is the authority who grants the power?
My lord may come to the rules, my lord. I have given the site, the Muslim laws.
Who power is it? Who is revenue? Yes. It's not revenue. He sometimes from DC. There's a big problem. His interest is sometimes conflicting. So we have to take note of Mr. Bhattacharya. You are pure breed revenue. Isn't it, Mr. Andy? He sometimes appears for the district also. So you are not prepared. Yes. That is the sad part of it. That is why you are putting the burden upon him.
Normally, my lord, he was not appeared in the bench, if it was not appeared. I appear at the end of the 4 matters here.
Hello. Yes, let us hear from Mr. Henrik. Because the letter has been written to the district registrar,
District Registrar.
and district registrar he also appeared. Who appeared for district registrar?
Not I.
Yes.
The Lordship may kindly see the advertisement is put it.
No, first of all, tell me, but does the revenue and disaster management have any role?
My lord, for my lord, creation of any post or my lord, any my lord MMR
MMR not only to that for notifying the area
But-
or for the purpose of bifurcating the area, does the revenue and disaster management have any role?
not disaster management have the rule. My lord, disaster management registration part.
Now, under such circumstances, show me that meaning
Rule 5 of the
Rule 5.
state government to provide people.
of the Assam Muslim marriage and
Muslim marriage code.
divorce registration.
That is, the state government shall apply for the office of every Muslim register to keep at the book necessary for the purpose. The basis of such shall be treated state.
Rule 5 of the rules.
Not mine. 67.
The limit within which a Muslim minor shall be licensed to act there coincide with the limits of public. At the government practice headquarters so
Now, my lord may also come to Rule 54. 54 sub rule 4, my lord. The powers of the permanent committee. The committee shall deal with the following matters.
Yes.
The consideration of all nomination to the post of Muslim registrar or Qazi, recommendations for dismissal and removal of Muslim registrars and Qazis, examination of Muslim register and Qazi, inspection of offices. They do not have the power to recommend creation of a or my lord bifurcation or dilution. So it is only by the government who has the power. And further, my lord,
no, but does the review
Right.
Not. Well, that it has been done by the registration, revenue department registration branch. They can find out that regarding the jurisdiction part.
that's the question up here. Because the rate the date
yes, ma'am.
My lord, advertisement and my lord, the paragraph 5 is something. Advertisement is given, my lord, Darapatal and Latu PICP police station. My lord, regarding my lord, the jurisdiction part or my lord, the bifurcation, my lord, it is done by the my lord, revenue department. My lord, I
First thing would not do unless an
Lord,
executive instruction or something.
Lord.
They have. Upon hearing the matter, it transpires that the council appearing on behalf of Revenue and Disaster Management Department is not ready to point out, it is not in a position to point out as to whether the Revenue and Disaster Management Department of the government of staff have any role in the in opening of a new MMR office or for the purpose recommending or for the purpose of opining that the Revenue and Disaster Management Department of the Government of Assam has no the Revenue and Disaster Management Revenue Registration and Disaster Management Department is not inclined to modify the license of the petition. But in that view of the matter, this court directs this matter to be discussed on 28th of February 2024. The Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, Revenue, Record Registration and Disaster Management Department shall file an affidavit as to whether the Revenue and Revenue, Record Registration and Disaster Management Department of the Government of Assam has any role in the creation of MMR office and has also a say as regards the exercise of jurisdiction by a Muslim marriage. The affidavit be filed by the be filed by 3rd of February.
There's an interim. There's an interim.
Okay. Same order passed earlier shall continue with the proposal.
Okay. This is matter, my lord, for settlement of Prime Minister Suraksha Bima Yojana.
Huh?
Prime Minister Suraksha Bima Yojana. And my lord, claims amount of rupees 2 lakh, and the person deceased on 2017. Thereafter, my lord, within 30 days we have applied and continuously we pursued my. Having no other alternative, we filed this writ petition in 2021. And the year 2022, my lord, they paid the amount.
They paid the money.
Paid the money in the year 2022.
Then?
During patent year.
Good.
Now, my lord, we have we filed this writ petition with claiming with interest rate, 9% rate.
Why?
Whether we are because they did not pay earlier. After 4 years, my lord, after 5 years, my lord, they paid.
Why have you approved so late?
We have approached immediately, my lord.
Hmm?
Immediately we have approached.
No. In the High Court.
High Court, my lord. They are, my lord. We are, my lord, pursuing before their authority, my lord. Continue. They given time and again and given the date that it should be paid. Even I visited about, my lord, 7 times.
Asking for interest.
That this is our
The instant petition has been filed by the petitioner seeking a direction. I am not asking you, meaning thereby I am not saying anything again. Seeking a direction upon the respondents, more particularly the respondent number 2 and 4, to settle and dispose of the claim of the policy bearing policy number A 21744 41,080 under the Pradhan Mantri Suraksha Bima Yojana PMSY in the National Insurance Company Limited connected with the account of the Karimganj branch of the United Bank of India. Now, Punjab National Bank bearing account number 0036010481014 at the rate of 9% per annum. The record reveals that an affidavit in opposition has been filed by the respondent numbers 4 and 5, stating inter alia that the insurance company had already paid the insured sum of rupees 2 lakh on 12/7/2022 in the concerned bank account of the patient. It has also been mentioned in paragraph number 7 of the affidavit in opposition that the insurance policy in question was connected with the United Bank of India Karimganj branch. So, under such circumstances, the relevant and required details like AIFT code, etc., for making payment of the insured sum amount as provided to the National Insurance Company Limited were of the United Bank. The National Insurance Company Limited had processed the claim diligently as per the company's established procedure. However, as the United Bank of India had merged with the Punjab National Bank in the meantime, for which the necessary details like the IFT and UTR code, etc., had changed, such particulars were not furnished to the National Insurance Company, for which the claim could not be processed properly at time. This court having taken into account that the petitioner have already been paid the insurance amount and the explanation so provided in paragraph number 7 of the application is of the opinion that the question of imposition of interest at the rate of 9% imposition of interest upon the national, the question of imposition of interest upon the insurance respondent number 4 and 5 in the facts of the instant case does not arise. Consequently, the instant petition therefore stands closed. Yes. What is this matter about?
We have been directed to submit a report, Lordship. This is the report we have received, Lord.
For what?
This is regarding a allotment of fair price stock. The petitioner has claimed that he should get the allotment instead
Who is
of
father? Is it because of the father? Is it the case where the father was to get it or
no, Lordship. Legal heir, Lordship.
legal heir? That is what you have given it to the respondent number 6.
Yes.
And the respondent number 6
That's
has
one
been
number
given
7.
6 or 7.
Lord.
And without taking into consideration that the petitioner is the legal heir for which there is a preferential treatment.
Lord. That is the case and that is the report, Lord.
That for your report stipulated the last stated that this report stated that there were some limited.
No.
Huh?
No, Lord. This we have received on 1st of February.
That was a submission which was made when the matter came up before this court earlier. So what is your basis to give it to him?
That is not reflected. That is not reflected in the.
No, no, here you are saying, although there was a, what you call, recommendation being made.
Yes.
In favor of the petition, but the area officers of MS Halaku PTS has submitted a report in favor of Krishna, the respondent number 6.
Yes.
That is the ground. So was it verified thereupon as to the capability of both the persons?
But it is not.
Or is it, or does the area officer of MS of the GPSS has the final say? I think when we bring it up the
By way of an affidavit.
question to the directions passed by Mr. H. Sharma, the learned counsel appearing on behalf of the respondent state, have produced before this court a set of instructions dated 1/2/2024. So, taking into account the contents of the state affidavit, state instructions, it is the opinion of the court that the state instructions be brought on record by way of an affidavit, so that the petitioner is in a position to rebut those allegations. If the matter again of 11th of March 2025 by 1st of March 2020, by 7th of March 2024. The interim order is continuing.
Yes.
Interim order.
Interim order dated, my lord.
Is until further order.
Until.
And because of that, this share price of what tax with another lot.
At 7. May I please, your lordship. This is my lord relating to my lord, officer of
Oh, that one.
security, my lord. Security money, my lord.
You have the notice in by.
Yes, your lordship, already that is there, my lord. Lordship may kindly see page 87. It will be filed by the respondent.
Yes, what did it say? Yes, the successful getter shall have to get the mining plan prepared and approved by the court. So you don't have a case.
My lord. My lord, two documents I will show, lord. My lord, the impugn order is, my lord, at page 47. That is, my lord, 12/1/2015.
Already been interrupted. It's already been interrupted.
By the said order, my lord, security money of 2 mining permit area have been forfeited and blacklisted. Blacklisted period is already over, my lord, so there is nothing. But this is regarding, my lord, forfeiture of security money. Lordship may kindly see. For the other mahal, that is Mayong Beach and permit area, we have prepared another writ petition before the honorable court. The honorable court already interfered, my lord. Lordship may come to page number, my lord. Relevant paragraph is, my lord.
Who interfered?
This honorable court, my lord.
Honorable court, madam, in respect to same kind of claim, but at a different mohon.
Eh.
At page 65, it starts, ends at 70.
70 and 70.
Paragraph 10.
Nine and 10.
does it say?
that both orders are checklisting and my lord, this forfeiture should be, my lord, condition precedent is that focus should be given. So 12-1 has 15 has been interpreted with. And forfeiture and departing a petitioner has been interpreted. There's a direction to release the security. Paragraph 10 conclusion.
Why there was no focus given?
Yes. So our affidavit, my lord, they are
But whether no, there are two.
Well.
For the purpose of debarring, a question of focus may arise. That's the case of black. But whether in the terms of the agreement or the terms of the tender conditions categorically mandated that there would be a forfeiture if you don't submit the mining plan.
the legal picture comes to flavor. There is a enabling proviso, if I recall, that if you don't do that, automatically it is terminated and it's what is consequently people still get.
This is what I said. If that is there, where is the question of focus?
Well.
Anyway, the learned council at the bar submit that a similar matter has already been decided by a coordinate bench of this court in deputy number 1258 of 2015, whereby the order dated 12/1/2015 in respect to another mahal has been interfered with on the grounds and reasons stated therein. This court accordingly is of opinion that the state matter, the instant requisition therefore be listed before the concerned court. Such date as may be fixed by the registry. My conscience is not.
Your Honor.
Yes,
Service report 5-9.
now orders. Then where is the service report business? Yes, what is the matter about?
Matter relating to some person constructed RTT building,
Now,
unhygienic
please
latrine,
do
urine,
directing the
washroom.
respondent
on
to
and
protect the
the
boundary
boundary
wall of the picture, removing all legal. Yes, what is it?
Matter relating to some person constructed illegally RTT building, unhygienic latrine.
Who has
What-
constructed illegal? You don't know. Chalo. Council appearing on behalf of the city state fair matter for which matter. Yes, Mr. What
My
is the
lord, in
matter
all
about?
respect, my lord, we have filed, my lord, and
That
section
matter came up before this court. Huh?
yes, my lord, Lordship, my lord, it was not in a prayer portion, my lord. Lordship said that, my lord,
There's an IA file.
Yes.
for the purpose of because early disposal, day-to-day trial.
Exactly, my lord. Section 14, my lord. And for section 14, the last paragraph will prevail, my lord. The proviso will prevail, my lord.
Which?
Of section 14
Of?
the act in question, my lord. That is, my lord, the Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act 1989. The mandate is, my lord, with all respect, my lord, from the date of filing of charge sheet, trial is to be completed within 2 months, my lord. So far the last proviso is concerned, my lord, of section 14, my lord. Here it has taken, my lord, more than 2 years, my lord. Out of 18 witnesses, till date, my lord, 12 have been examined, my lord. That is at page 50.
But Mr. Mohan, what remains in the writ petition?
Only that
As
part.
of now, what remains?
That is why, my lord, in that writ application, my lord,
Nothing is.
absolutely, my lord, only that, my lord, section 14 is to be followed in totality, my lord. And that is why Lordship said that, my lord, we have to file an additional application. That is in your Lordship's order, my lord.
This is done under whom? By the PP?
By the special court, my lord, even well, that special court has to be absolutely a special court, but that cannot be done possibly under the circumstances in Assam, my lord, with all respect, my lord. Very few and far between cases under this act, my lord. Only that, my lord, with all respect, my lord, but you could kindly will look at section 14 last proviso.
As far as practical.
Yes, absolutely, my lord. Here, my lord, not 2, 4 months, 6 months, 2 years. My lord.
But
It's possibly the court,
the
my lord.
court can very well ask the prior
So,
because the PP has been that
direction has to be possibly to the court.
no, understood. The court can be the direction. Main problem is this: it is outside the scope of your institution.
Yes.
Can you, by way of a mistake, bring in something which is specifically outside? It is not a question of investigation.
Not, my lord. So here it is charge sheeted, my lord.
No, understood. But there is nothing else. The last of the prayers released for is transfer of the trial of the instant case to any other nearby court in
No, no,
Hamrain
no,
or something. That
So,
is the only thing which is left.
yes, my lord.
Now, if it is not done within the purview, can an IA enlarge the scope of the restriction?
Because it is there in the act, my lord, only reiteration of
The
law.
act, therefore, you can very well show it to the authority. And if it is not
There,
done,
even that prayer was when they were granted the privilege of bail, my lord. Even that prayer was made by the PP to the court, my lord, that day-to-day basis it is to be done, my lord. Even then it was not carried out, and that order is at, my lord, page 39.
the person division would be better.
That would be, my lord, father, only technicality, my lord, only that part.
You see, this will be going outside the scope of it. Don't you
Lordship.
think a review, you filing an application, if it is not done so, then you're moving under 227 or a revision would be better.
And only reiteration of law, my lord, if that part can be given. That is why we filed it, my lord.
Understood, but that is outside the scope.
Because of the IA, my lord, lordship, that is why directed that. If it
IA, no, therefore you have filed the IA outside the scope.
yes,
Because
my lord.
you need to do so if you file a review. Then this court can very well, you see, then the direction, this court would then be exercising a jurisdiction. As of now, what you are asking,
Yes.
any direction pass is a writ.
Yes.
Now, can a writ be issued in under 226?
Yes.
No?
Yes. Yes.
There the problem arises.
If lordship finds a saving grace, my lord, that would be better. Only, my lord, those that people, but only law is to be reiterated, my lord.
Oh,
nothing.
if the law is already there, why do I need to reiterate it?
Because, my lord, not carried out.
You file an IA, file an application, I take no quarrel with the decision that you are fair, but is it the proper form?
If that
Still,
can,
an investigation is going on, okay, 226, I can exercise. But the moment I direct that and kindly to do so, direct the authority to abide by the mandate of section 14, which
Can it be, can it, can-
already the law mandate. And if I have to again direct the court issuing a writ,
can it be in this manner, my lord? Of course, my lord, I do not know, my lord, whether I should make this prayer or not. To quickly, my lord, to make this prayer before the court, my lord, government, my lord, to get up. Then it will be carried out. It will be the scheme of things.
it's not yet. Whether you find that another decision you are getting. Oh, the main reason. Or Mr. Pikin, not just the council appearing how it has been duly submitted, but the council appearing how that in the meantime, the charge sheet has been duly submitted in the year on.
My lord, the date is, I'm taking a minute, my lord. It all left it, my lord.
Will be there in the eye.
Yes, yes, I'm pressing. I'm taking a minute, my lord. Not too late. My lord, it was filed on, my lord, with all respect, my lord. 2621, my lord.
Charge sheet number.
Yes, yes. my lord. It is not given as a prop, my lord. That occurs at page 26, my lord. My lord, 79.
Charge sheet number 79, dated 2021, have already been submitted. Whereby the accused have been charged under step 2, second, step 2, second, I, step 2 of the right bracket and the timetable to be act and second for the timetable to be act. Yeah, however, submit that although that pursuant to the submission of the state charge sheet, the trial, the proceedings have been registered as special bracket SCST bracket close case number 01 bracket N oblique 21 and is presently pending before the special judge Nogam. The learned counsel further submitted that although it is the mandate of the provider to subsection 3 of section 14 of the Scheduled Caste and Scheduled Tribe bracket Prevention of Atrocity Act 1989 to complete the trial within a period of complete the trial as far as possible within a period of the date of filing of the charge sheet. But more than 2 years, 3 years,
Yes, I'm sorry.
almost 3 years have passed by. Almost 3.5 years have passed by. 3.5. 3.5. It is 1,
3.5.
almost 3.5 years have passed by. But till date, there has been no culmination that the trial proceedings are still going on. This court have also taken note of that the instant petition was filed primarily for the purpose of primarily complaining about the delay in the investigation of Roha Police Station case number 97 of 2021 and for ancillary reliefs. The said proceedings, the said investigation had culminated and on the basis thereof, charge sheet number 79 was filed on 20. Therefore, in the opinion of this court, nothing further survives to be nothing further survives in the instant writ petition. More so taking into account the charge sheet in question. More so taking into account the content of the charge sheet in question. According, the instant writ petition can close as it had become infructuous. Before parting with the record, this court, however, duly taking note of the submission of the mother, observe that it is the mandate of law in terms of the proviso to subsection 3 of section 14 of the and Tribe Prevention of the Act 1989 to complete the trial as far as possible within a period of 2 months from the date of submission of the charge. It has been stated at the bar that the state trial proceedings are still going on. In the present proceeding, this court would not like to pass any order, or issuing directions. However, grants the liberty to the petitioner to request the special judge Nogam to take appropriate steps so that the criminal proceeding, that the state proceeding being case number 7 is decided at the earliest.
Highly obliged. Obliged, ma'am.
It
Obliged.
is as far as I can give.
Mile.
To order.
Malad, this contempt petition has been filed, Malad, for willful violation of the order dated 21/2015, Malad. Cooperative portion is at page 9, Malad.
The order.
You got the money.
They had paid, Malad, I have no guarantee. And anyway, Malad, they had paid, Malad.
Epoch Medi and Aya Enterprise.
Enterprise.
Behalf of the submitted, placed an instruction issued by the Executive Engineer Gwalpara, WR Division, to the effect that the petitioner number 1 have already been paid an amount of rupees 81,427 through online mode on 28/12/2023, and the petitioner number 2 have already been made payment of rupees 1,23,572 on 29/12/2023. The said instruction is kept on record, taking into account that the order passed the court have order passed by dated 21/5/2000. The 14 have been duly complied with, for which the content to be right.
Public.
Yes, my lord. That is the lordship. My lord, matter is related to the my lord. There is specific direction from this honorable court, my lord, to make payment to the petitioner, my lord, about 30 lakhs, my lord. Your lordship kindly come to the page 10, my lord. Page 10, my lord. The petitioner, come here. The complaint paid for an amount 30 lakhs 90 have raised. It is the therefore they file a writ appeal also, my lord. That was also dismissed, my lord. That page 18, my lord. Page 18 of the contempt petition. Yes, my lord. The case is, my lord, that my lord, what happened, my lord?
Have they made the verification?
They made verified, my lord, and amount is, my lord, 30 lakh. What happened, my lord? Your lordship kindly go to the, my lord, their affidavit, my lord. Yes, sir. In affidavit, they have certain, my lord, para, my lord. Para, my lord. They 8, my lord. That's page 3. Yes, my lord. 15 lakhs has been paid, my lord. And they fraudulently took the signature in a, my lord, in a, my lord, in a letter paid. That payment pool has been made, my lord. And they have withholding the 15 lakhs. We filed the FIR. They are, actually, my lord, I am coming, my lord. 30 lakhs is there.
15 lakhs.
They pay 15 lakhs. There is a, my lord, clause of the tender, 50% paid by the state government and 15% shall be paid by the NERAMIC, my lord. The state government has paid their part, my lord, as per the case 69, to the, my lord, NERAMIC whole 15 lakhs, my lord, that 50%. And terms and conditions, you have to release 90% immediately. That was also not done, my lord. I am not on that, my lord. What happened? They paid 15 lakhs to the petitioners, my lord, and said this is the part of NERAMIC. What amount they have got from the state government, they are signing in their affidavit, my lord. Till today, that 15 lakhs was not paid, my lord. That is the case, my lord.
If it is not paid thereafter, it's the question. They say that they have did the verification. The 50 lakhs. Matter ends there.
My lord, kindly allow me, that is why, my lord. Just 1 minute, my lord.
Nothing up to paragraph 10 of thereafter.
Yes, my lord.
You see, order passed by the you make a verification.
Yes, my lord.
Not verification.
They
Now in paragraph 10, they have.
Yes, I'm reading that part, my lord. The answering, para 10, my lord, last but 4 line.
The answering
No
respondent.
need for last but put it.
Yes, but I'm reading whole my lord. Thereafter, I am coming my lord reply. That the petition of actor Esther to 12 contempt of the name of the suspect was submitted there. It appeal so and so narrowing, but the said dismissed by order dated 6/9. Thereafter, compliance of the constituted committee conducted a detailed inquiry verifying invoices submitted by the petitioner number 15. The amount of the petitioner. The hearing were amended along with the respective. The committee submitted its report 11/9 is based on the recommendation of the committee. The answering respondent paid their share. That is important, my lord. Paid their share, my lord. 15,66,74 only to the petitioner number firm against its two invoices, so and so, so and so. Good, my lord. Naramik has paid 15 lakhs. Then, my lord, it is condemned by the state government. But your lordship calculated 69, my lord. Annex my page 69.
But it, what?
Yes, my lord. Repeat in opposition, my lord.
No, these have been filed by who? Arabic.
Naramik, my lord. State government has
1,
not.
3, and 4.
Yes, my lord.
One is donor.
Yes, my lord.
Arabic.
Naramik, my lord. Yes, my lord.
Now, but the remaining is to be paid by 5, 6, and 7.
Yes, my lord. And they that part has been paid by them to the Naramik, my lord. As per 69 of the Philippine opposition. Let's kindly look. Yes, my lord.
But
Indian of supply micro tiller all associated under the scheme of so and so, wise physical and financial allocation is under. This is, my lord, relating to the, my lord, Sonitpur and Baksa district, my lord. 20 from the Baksa district, 25 Sonitpur district. Their part has been paid, my lord, 18 lakhs, 14 lakhs, and 14 lakhs 32,000. If you look,
no, where is the verification? Who is appearing for the other respondent? 5, 6, and 7.
yes, fine. Government will let them.
Why will the government appear? Have you noticed?
Yes, but notice has been issued, madam. No one is appearing, madam.
Oh,
Or government also
whether these
contact.
people are still there,
Yes, madam. No, my lord. We file a substitution petition, madam.
then you
Then,
should
my lord,
notice.
that person is already been now, as per my
Have
instruction,
you
my lord.
should notice.
They are also retired, my lord.
Huh?
Just now I came to know that that person is also retired.
You want to make this fight more thicker and better.
One thing is that, madam, there is an order filed by this
So we
honor.
drop the contempt proceedings as regards respondent of the one year. Drop the JP.
My lord.
We drop the contempt proceedings as regards 1, 3, and 4.
No, my lord.
Why?
Because that amount has been there. That is 69 says. They have paid to the Naramik that amount. That's per Annex 69, page 69. They paid that amount, their share, to the Naramik, my lord.
What is the order passed?
This honorable court has directed to pay 30 lakhs.
No, where is the direction pay 30? To me,
Yes, sir.
to verify and pay.
Verify and pay.
So,
Yes,
where is the amount being quantified at 30 lakhs?
Yes, sir.
So they have verified and said that 15 lakhs is their share, they have paid. So if you are agreed, the case of a restitution,
But my lord, other respondent has not been paid.
that's for the I think that so they say that they have paid. Unless so that you have not paid.
I have received 50 lakhs, my lord. That was
And
not
this
denied.
amount that you keep and that is also there is a check out there.
Yes, my lord. That amount has been paid, my
And
lord.
this check has been issued by Nerabic.
Yes, my lord.
Then from where the Nerabic got the money, how am I concerned?
But Director of Horticulture paid their part of share to the Naramik.
You do one thing,
that
you
fact-
file all these things in a restitution.
My lord, one thing is that, my lord, in affidavit they have concealed this tax. my lord.
This court, if they have made a verification even wrongly also,
My lord, there is an order in IA, my lord. If you love to go to the order, my lord, before my lord, deciding this matter, my lord, there is a substantial dispute whether the amount is already released in favor of the petitioner in total compliance of direction of this court, my lord. Lordship kindly look to take 23/10/2019 order as by this honorable court. In I8
Arabic have paid, have put their committee, they have taken the
liability for their share.
and they paid.
Yes, 50%. Other 50%.
Whether they have bought for the other person or not, paid.
But as per terms and condition is there, 50% fair share payment will be paid by the state government to the Neramic, my lord. That is the crux of the issue, my lord. You're also pay 69, my last part, my lord.
Let us see the committee. Yeah. Detect the fact.
This is their part, my lord. I am they are my second committee. The Lilador is certain committee report and answer respondent 29/8/2000. The committee member again assembled the meeting. That was cleared, my lord. Respondent number 2 is the yes, sir. Yes, sir.
How many
45. 45. Yes, my lord. 45. My lord, if I supply to the 45, my lord, and the amount the bill is, my lord, for 45, 30 lakhs, my lord. They, my lord, never denied this tax, my lord.
No, how
Your
can
lordship,
consider this? They come up out here, they did not say page number 33, they did not say that it is the amount.
lordship
They
kindly,
categorically say page number 33, that is the total.
lordship kindly come to, for their share, my lord.
Why? There's no there, here, there, right here. I look up to page the paragraph.
Yes, sir.
There's the word there. Page 32, paragraph. Converter.
Yes, my lord. Considering the elaborate above, more specifically, the controversy issuance, the NOC has been resolved. The committee member recommend release 15 lakhs rupees 15,60,000 to Mr. Liladhar Roy for supply at the invoice 25 Matirata Solidpur district and 16 so-and-so 20 Tala district. That is not the full payment, my lord.
So, for the civil court, we are agreed. How can this go to district? It is the finding. It's a finding. You know,
Well, I have to take some steps. I have to give some time, well, I have to go all these things back. Well, I have to go.
I'm taking up this matter. Take it up.
Well,
Then that-
only my lord, one day.
Yeah, this fee. Oh, that file should not remain any further.
No, my lord, only Monday, my lord.
No. Take it up after some time, after taking Mr. Mahmood's time.
Monday, if my lord, I shall go all these
No,
things.
no, not necessary. I did get the matter also today. Thereafter we'll see. Because you see, any further delay, it will only delay your client.
My lord, my humble purpose is before your lordship there is the admitted position is that page 69.
Who
Yes.
had admitted?
50% of this share, the government, my lord, has paid to them. At that amount is the beneficiary share as categorically mentioned, my lord. And if your lordship added this thing,
I am not
30 lakhs.
concerned with the 50% treatment. See, what is the terms order is clear. You verify to a committee, they verified and found from their paragraph 31 that this is. However, you say that your amount is more. So therefore you go and file petition or whatever maybe you need to challenge that document, saying that no, it is not 15, it is 30. Take it up. That's how you get a mark it up.
My lord, then I said, well, highly repeat it up. Because
I'm not saying pilot. You may have to challenge that document.
Yes.
Without challenging the document, in
My
a-
lord,
in a-
only
you
one line,
cannot-
my lord, 147, my lord.
Huh?
147.
What one?
Page number 147.
Yes.
Payment of schedule as approved rate for the year so and so, so and so.
So all these things, I think the report tell you, or the report will be- I think
And my lord, that 146 with FI, you are hereby requested to.
all these things are the problem
Yes, my lord.
arises that not the-
Yes, my lord. I am submitting before your lordship is that, my lord. My case is something different, my lord.
I
They
am
have paid their share. Naramik share. So far,
Mr.
50% is
I am,
concerned.
and I really understand that. I have understood what is your, and if you want, I can note it down. I'm passing that order. You say that if there is anything
And
Therefore-
what is the answer? They are not filing the
Enough.
affidavit.
we have heard. But it-
And the one PM.
It has however been submitted with five, six, seven are not presently manning the officers against those officers which they have been seated arrayed as a part. It is a state. The state intended by the initiation of them for which to fight for the fight for the the state order. Wherein it has been the respondent number 2 is the state that not that it is not corporation. If I filed an affidavit, however, before it made it very clear that while the court of the court had made very clear while this However, dispose of the receipt, the director to verify that well, what the right take but always it was also mandated.
My lord, exponent number 2 not file affidavit.
So also the verification of it as the law that paper, whether that ever the director to complete the date decided to the date third time of it. The record is that pursuant to the passing of the state order, the payment was not received on a pursuant to the state order. The petitioner received did you receive any account?
Yes, my lord. That was the final.
The record is that was pursuant to the state order. The petitioner did not receive any amount
In reply, I
for which the instant concept receipt was 19,008. It also seems from a picture of the activity by the one that the order passed by this court dated 5/4 in the 7 but it says it before the petition page but the state receipt was dismissed by court 6/9/2017. Under such circumstances, in compliance with the order 5 of the 17 passed by this court in the therein constituted a committee that conducted a detailed inquiry verified the invoices submitted by the open firm and the amount paid to the the hearing were attended. The also mentioned that the hearing was attended by the petitioner of the two states along with the committee thereafter submitted for and based on the recommendation of the narrative paid their share of 6,700 to the again 2 invoices paid that submitted date number and are at this stage, this court also finds relevant to take note of the report of the committee dated 11/9/2018 have been enclosed as Exhibit F, the affidavit filed by the court. Paragraph 31 of the state court being relevant is what here is to do. The above exercise which have been carried out therefore shows that the direction which was given by this court on 5 of was a direction to narrative to make verification and then to make the payment. A perusal of paragraph number 31 of the report as have been clearly shown that the same verification was duly conducted, and it was found that the total amount due to the PIT was 50,66,774, and according the same amount was to be paid. In the background of the above, I find it very relevant to note of the subject of the after the hearing on behalf of the issue to submit that the actual due the PIT is 30 lakh.
Yes, my lord, 30 lakhs, 92,000.
It is 30 lakh 92,571.45 paisa. Whereas only an amount of 15 lakh 66,774 have been paid to. It is the opinion of this court that from the order dated reading of the order dated 5/2017, 17, na? 7, that there was a direction to the NAREMIC to carry out necessary verification and to make payment. The report, as mentioned here in above, and the relevant person quoted clearly show that the verification was done, and thereupon the payment have been made. Under such circumstances, it is therefore the opinion of the court that there is no further violation to the order dated 7/4/2017, passed in the PIT number 7/2016. Be that as it may, this court makes it clear that if the petitioner is otherwise agreed with the committee, or for that matter, the committee have not granted the actual dues, the petitioner would be at liberty to put the appropriate form in that regard. Very such factual determination can I according to concept of that a good finish of it. But then another thing.
May it please your lordship. Lordship, I have preferred this IA to take the steps upon the respondent number 5 lordship in his new address. And the address is reflected page 9, paragraph 9 of my IA lordship.
Which one?
Lordship, the respondent number 5.
Rajiv Singh,
Rajiv Singh.
Dev Bahadur Singh.
Yes, lordship. 6.
That one?
Yes, lordship. that one.
Allahabad.
Allahabad.
The instant application has been filed by the petitioner. It's a directive that the petitioner may be permitted to take a step upon the respondent number 5 in his present location, which have been identified as 68 Southside area, Arsana, taking into account that the state address have been taken address to collect after making due inquiry. This court permits the people to take steps by way of registered court along with the in the new address in the appropriate I court will take steps by Accept it.
Much obliged.
Bye. Yeah, what is it?
Lordship, it's for correction of mistake, Lordship. But on last occasion, Lordship directed me to submit the judgment and order before the chief engineer. So accordingly, the judgment order submitted before the chief engineer, Lordship. So matter may be taken after 4 weeks, Lordship.
They go take a type of
No, Lordship,
there was some
Design-
name being indirectly put out there.
Lordship, that was initially mistake
had-
were in the mistake in the repetition. So subsequently, designation of respondent number 5 was corrected, but that
I had.
by hand, taking permission from the court. But the computerized mistakes were remain, Lord.
Computerized debate like that. Anyway, we can, we can say that the IA is but they were so that concern executive engineer.
Executive. That is
Executive engineer step two.
executive official, Lord. That is the code.
They have been-
And that effort, Lordship, one date
In
was
application has been filed. Taking a direct permission to allow the applicant to correct the designation of the respondent number 2 as the commissioner and secretary to the government of Assam and respondent number 5 as the executive engineer. And what is the date?
first of all, on 21 is 2021 bill was passed. In that, some amount was withheld, Lordship, and that date was mentioned to one paragraph as 21/8/06. Just would have been 21/8/20.
So this is a mistake by this court. The
No,
order.
Lordship, in the repetition, one paragraph it was correctly mentioned, but one paragraph it was typographical mistake. Lord.
And for correct of the date. Para number 82.
It was paragraph
By
10
order,
page 11.
by order. Para number
In the paragraph in order, Lordship, it mentions that
where? The council, like the learning council appearing, learning council appearing on behalf of the applicant being not ready, prepare the matter. The have to be ready when the matter is taken up. The court was inclined to pass orders so that have helped you, but sorry to say,
no problem.
yes. What is your right?
Our case is this, my lord, here are 536%.
and they were allotted certain plots of land, but so they were occupying certain plots of land. They are landless people. Admittedly, there are so many certificates, and they are local people. And this Honorable High Court, by an order that may be seen page 183, operative portion 191. Last para, in view of the conclusion recorded with regard to the impugned notices, it is further provided that till such representation is disposed of, the petitioner's possession of land presently occupied by them shall not be disturbed. In the event of the representation being filed, being rejected, the authorities are inclined to get the land vacated. They would follow the procedure prescribed by law for such purpose. It is further made clear that if no representation is filed, it would be open for the state respondent to take appropriate action against them as permissible under the law. So this was the order passed long back.
You were a part,
My lord,
you were part,
yes, the majority of them were part.
majority of them. We are having 536 petitioners and there
No,
were
all were not
24
there,
families in the earlier representation.
but they have also
Huh,
represented.
Not even 10%. Why you are saying the majority? You see the first part of the judgment,
No,
it
there are-
clearly says that it is for 54 families. And we are here taking care of 536 petitions.
In court's order, my lord, that is there, but all of these persons, either individually or collectively, file various representations.
No concern, but they were not a part.
No, they were some of them were not part.
Not back.
Now, lordship,
Only
thereafter, my lord,
10% was.
kindly see page 192. This is the representation after passing the order by the Honorable High Court. And in that case, my lord, this was filed after the order of the Honorable High Court. And at that time, land was
Okay, then what happened?
208. No action is yet taken.
Huh?
No action is taken by the government. Only without disposing our representation, they issued further notice. That has been stated by the Honorable High Court. They issued further notice to vacate the land. I think he has to vacate the land. So that notice, may lordship
How
may
many
kindly.
people have submitted a representation?
Yes, that was submitted on.
Kindly see your representation is of page 192.
Yes.
Hafizuddin and 54 others.
Yes.
What about the others? Why the others have been dropped?
This representation they are harping upon doesn't contain anything. No, neither endorsement, neither date.
No,
No, anyway,
Why you say
it's only
like
54.
Kindly
And
see
signed
page
by my lord only 5%.
192. Submission of Honorable High Court's order dated 7/1/2004, passed in civil rule number
It's
330.
okay, then what's the order?
Yes. Then, my lord, their latest system was that it is forest land.
Huh?
But forest land, there is no such any document there annexed. And over and above, a plot of land has been also allotted to ME school and LP school. That is page 195, 197. So there is no mention that
Is
land
this
is
forest land?
forest land, they say, but no document.
So where is the notice? Where is the notice for you to?
Yes, notice, input notice, page 181.
Hereby inform the Senate of the what's wrong with
No, wrong is this one. This is forest land. There is no proof. How they can, only they are saying is there. No
so
notification is.
this is a notice in general. If you are not in forest land, how will this affect you? I put the that there's a your name. It is saying that this area, the anybody illegally occupying any reserve forest or proposed reserve forest, the construction they are
That is the
are
logic
you
is correct.
admitting that they in reserve?
No, reserve forest means because we are threatened. We were threatened otherwise.
First of all, the question of technical land does not arise. Secondly,
No, I don't
because the reserve forest
Cannot be settled. Now, this is their new discovery because
and
they
it is
have,
the proposed reserve forest.
no, I understand that. But my lord, this is their new discovery because they have already allotted land in the name of few schools. And there is no mention,
Who have allotted?
the government has allotted.
Therefore, obviously the government have not allotted in reserve forest.
Where's that 195 kindly?
It is in reserve forest.
No, no. It is not written. That is our step.
Therefore,
But
the
that-
land is
that-
not there. Where is your power? How are you affected?
the village name is Ashudubi, and Ashudubi village, a part of some portions of several bighas of land have been allotted in the name of ME school
Fact
and
is notice, it's a general notice.
General.
You also
That is
apply out there in Kaziranga.
practically, well, that was meant for us.
There was ahead of the that the part of the 500 was ordered.
177.
Both part 179, 177, 524, 173, 282 bighas.
Or you are challenging these notices.
This number six.
520 bigha of land, it is written as Mohoral. This is absolutely beyond record. Mohoral has no such record that, but in our case, we have record. We have record. The land was, electricity was provided.
No, Mr. Mahmood, RT notices so that RT.
Yes, that is in the name of Mohoral.
On any of
The petitioners, among the petitioners, Mohoral, Lordship, let me verify. Mohoral. Yes, his name is the serial number 24, petitioner number 24.
so what basic but
No, he has not occupied. This is wrongly written.
that what take action if you got a reserve for it, take action. Take action. Nothing doing. That matters because
No, reserve forest, my lord, they
sorry,
orally
Mr.
they are
Mahmood.
claim, but where
So
is the
if it
notification?
reserved for it, first of all, it has been issued to 2-3%, not to others. Now, if these notices show that you are in occupation of 524 acres of land, the common land, so first of all, how permitting a person to occupy, even a person owner of a land cannot be a owner of a 524 acres because the ceiling would have failed.
That is. And one thing, my lord, they are saying
The
forest
second thing
land,
is,
forest land, but
the
where is
petition
the,
should have been filed separately. Why all the people have joined together?
cause of action are same and
What is the cause of
relief
action?
short for also identical?
Now, are you in occupation? Are everybody in occupation of their own land?
No, that is not. They are a very small portion of land.
Small
They are-
means
They are landless people, so they were
how much?
allowed a very
Then why
little-
are you bringing in Annexure 12 series? It's shocking. Annexure 12 series.
Yes, notice so many persons have come. Actually, there a reasonable apprehension, they had a reasonable apprehension that these things would also happen.
First of all,
Yes, that is true. But my lord, whether it is reserved land, there
it
is
is
no
not,
notification.
it is okay. You admit one thing, that in a reserve forest or in a proposed reserve forest, not have a such.
Yes.
Do you agree or not? Unless you come within the ambit of that schedule, those that act, the dwellers, tribal dwellers there.
That's it.
So that is another aspect of the matter. There also, you are to file your objections. If it is a proposed reserve forest, you are to file, but in a reserve forest, you need
One thing, my lord, we have annexed one order of this Honorable High Court,
this
page
court
199.
order, court not going to do.
Page 199,
No, I could.
that is Amsang order. So that was also like in similar case, some protection has been given, my lord.
There is no question of protection.
No, my lord,
In
it's
the
being
reserve.
monitored now. It's being monitored by the High Court, it's pending. The mass evictions are being planned.
Do whatever. But this is not a case for it.
But no, my lord, that was disputable one. So far, if the forest land is there, a notified forest land, then only they may take action.
If not only that, if you are in government land, then also they have the power, but do so in terms which the provisions of the settlement.
Chalvan rules, yes, that is true. That is true, but
Representation business out there. You see, now the concept of representation, yeah, that's not what yeah, but now there's not what they put it there out there.
no, here, my lord, I don't lost kindly space 129 for a moment. 129, this is Jamabandi. Here, nowhere it is written that this is forest land. It is Jamabandi in our name. So some person's name are there. Page 199 and 129 and 131, kindly see, these are the Jamabandi. So there is no mention that the lands are forest land. All of a sudden they are coming and saying that it's forest land.
And you'll see that document, but you will see the Sita part. The remarks, madam. Sita has been recorded in the name of Bedpari LP. Even that document doesn't support us.
No.
129
How do-
remarks
how
per
is-
madam. See, Sita has been
129, first one after 129 C. It is in the name of village Ashudubi, and that land we are claiming.
remarks
And Abdul Sawan, Sita record has been corrected in the name of Bedbari LPC represented by headmaster. So here now my intention is that it is not forest land.
Mr. Mahmood, you are challenging Annexure 13.
Yes.
At the end.
Notices.
The instant with only one notice. Annexure 13 is only one notice, that big notice. Then you come to page 181. That's Annexure 13.
Yes, right. That is general notice.
The general notice, hey, if a person who is there in a reserve forest or proposed has no right, they can be forest.
But that loss may kindly also observe that
has been filed.
if only forest land is
The notice dated 6/12 of 30 by the on-project forest officer, the reserve forest, which as further for that, the president directed for that the bank get interested but the eroded of the day up to revenue. Yeah. So it is the Walpara covered by dark a code of the name for the after to verify and to recognize identity and this code have duly Peru from a Peruvian it is that 536 petitioners have joined together to file the instant petition challenging the notice dated 6/12/2017. It is apparent from this court have duly perused the notice dated 6/12/2017, which stipulates that the wherein notice was given to the general public that those who have illegally occupied the land of the reserve forest bracket RF or proposed reserve forest bracket TRF by constructing dwelling houses, they were directed to leave the forest land within 31st of December 2017 and to make the forest land completely free. It was also mentioned that if there is, it was also mentioned that appropriate action would be taken against illegal land occupiers as per the departmental rules. So this court, taking into account that no rights can be created or accrued in reserve forest or proposed reserve forest, is of the opinion that there is no illegality in the notice dated 6/12/2017. Which, be that as it may, it made clear that the forest authority can only exercise such jurisdiction in reserve forest or proposed reserve forest and not in respect to other revenue lands. Full stop. In such revenue lands, it would be the jurisdiction of the district administration.
Earlier order of the High Court.
In addition, there is also a prayer made in the writ petition that the land measuring 300 feet cut 7 kilometers in village of 250 between revenue circle Mutia and K. Krishna in the district of Walpara, covered by tag number 274, 277, 229, and 228 old public 261 new to be settled in the names of the. It is the opinion of this court that if the petitioner seeks settlement, the said settlement has to be made. The said settlement, seek allotment and settlement of land. The said has to be made by filing appropriate application before the district commission. Walpara.
It is done now. Best 135. But they have not discussed of it. That is our demand.
No, not like this. People with Walpara. As per the loan policy of 2019, district commission. Walpara. However, these applications cannot be a conjoint application in as much as each and every cannot be a their respective application before the commission. So it is applied that if the petitioners duly file applications, their respective application seeking allotment of land, the district commissioner, Walpara, shall duly consider such application within the purview of the land policy of the year 2000. However, the said observation shall not in any manner affect the forest official to take steps against any intruder in the reserve forest or the proposed reserve forest. The above, the